member join us later. And at this time, I would ask Vice President to take the roll call.
Mr. President, I think that is a function for the Secretary. Is the Secretary in today?
As I requested, Nilsa, he's not logged on yet.
Okay, thank you. Let me pull up my board packet. Thank you. Okay, great. I'm ready.
Good.
President Tianfen?
Yeah.
Nelson Serrano here. Robert Perman? Okay, absent. Malcolm Brett Gladstone? Okay, Ronald Jones?
Present.
I saw his name.
Present.
I saw Brett's name.
Brett,
issue.
Brett, can you please announce yourself? Is his audio working, moderator?
This is the moderator. We did a mic test before the meeting. He's muted right now. I can send him a request to mute himself.
Please, thank you. Thank you. And while he's doing that, we'll move on. Mitra Kanani. Mitra, can you unmute yourself and say you're here? I saw her also, right? Okay, she's waiting in confirmation that she is in the meeting. Okay, Sylvia Kwan. Ebony Lewis.
I'm sorry, do you hear me now? This is Mitra.
Yes. This is me. Hi, Mitra.
Okay,
Thank
great.
you.
Great, I'm glad.
Okay. Ebony Lewis. Is Ebony in today? I don't see her. Okay. And Charles Ward.
Present.
Thank you. Mr. President, roll call has been completed.
Thank you. We have a quorum. We have 6 attendees. And we want to start the meeting and move to agenda B, which I will announce that the meeting is being webcast pursuant to the provisions of Governor Gavin Newsom's Executive Order N08-1 dated June 11th, 2021. This meeting will be held by telephone conference, no physical location. With us today, so 2 members from LATC, John Luzinski and Patricia Trout. I want to make a formal introduction of our new member, who was recently appointed by Governor Newsom. That is Mitra Kanani, and will serve as architect member of our board. And this is her first meeting. Mitra is also a lifelong educator. Mitra, would you like to take this opportunity, maybe give a remark to the board?
Yes, of course. I thank you very much for introducing me. It's a great pleasure and honor for me to join this esteemed team. I have been with Architectural Collaterals for quite some time, for as long as I've been an educator and practitioner with Council Registration Board, NCARB, with AIA, American Institute of Architects, and with NAB, Accrediting Board, that I had the pleasure of working on one assignment with Tian. And also I was the international evaluator for 15 years with NAB. I have to say that having this honor to be part of this board is extremely exciting for me. I'm looking forward to it, and I will make every attempt to be an effective member.
Thank you, Mitra. Welcome again. Also, Mitra is based in San Diego, the south tip of our state. So that contributes the diversity, Mitra.
Yeah,
of the
that's
region.
great. That's great.
Um, okay, so
Mr.
just
President?
a procedural remark that all motions and the seconds will be repeated for the record, and the vote on all motions will be taken by roll call. Vice President, if you don't mind, you continue help us on the roll call until Robert Pearman is signing to the meeting. This time, any public comment that is waiting before we move to agenda C.
Mr. President, I believe we have some additional members and should do another roll call at this time.
Yes, I was going to mention that.
Okay,
Okay, Ebony Lewis. Ebony Lewis. Okay, Robert Perlman.
Hi, can you hear me?
Yes, we can.
All right, thank you, Nelson, for stepping in.
Thank you. Ebony Lewis, I saw her on the camera. Okay, I guess she's not answering. Is Sylvia Kwan in now? No? Okay, thank you. That's it. So we've added Robert Perlman to the
Rick Gladstone here.
Oh, and there's Sylvia Kwan. Sylvia Kwan, can you announce yourself, please? Are you here?
Yes, I am.
Thank you. And Sylvia Kwan has joined the meeting. Thank you.
Rick Gladstone, can you hear me?
Yes, we can
yes,
hear you.
we can hear you. Excellent. All right.
Thank you.
Thank you. Now we have a full attendance. We're going back to asking for public comment. If any public comment is waiting before we move to agenda number C.
This is the moderator. Thank you, Mr. Board President. I have opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please type. I would like to make a comment or comment using the field in the lower right-hand corner of the screen and send it to all panelists. We are displaying instructions for your reference, and we'll give you a moment. All right, Mr. Board President, I see no request for comment at this time. Would you like me to close the Q&A panel?
Yes, please.
Okay, it's closed.
Our agenda number C is update from Department of Consumer Affairs, DCA. And we are very glad to have Deputy Director Carrie Holmes with us. Carrie, if you're ready, the floor is all yours.
Good morning, Board President Fang and board members. I am Carrie Holmes, Deputy Director, Board and Bureau Relations at the Department of Consumer Affairs. Thank you for allowing me to provide a department update. I would like to welcome Mitra Kanani as the newest member of the board. Congratulations on your appointment and thank you for your willingness to serve. DCA is receiving many questions about when and how boards will meet again in person and whether they can also continue to meet remotely. As the law and executive orders stand today, after September 30th, boards and committees will be required to return to in-person meetings with publicly noticed meeting locations. However, due to the ongoing changes in the COVID-19 pandemic, there is legislation pending that would extend the ability to meet remotely until at least January 31st, 2022. We don't have concrete news today because it needs to be passed and signed, so DCA will do all it can to assist boards and bureaus to plan safely for in-person meetings and keep you informed of changes to meeting requirements. To combat the spread of COVID-19 and protect vulnerable communities, California is implementing enhanced safety measures for state employees and workers in healthcare settings. State employees must show proof of vaccination or be subject to regular COVID-19 testing and required to wear appropriate PPE. Board and committee members are considered employees and must follow health and safety protocols if they plan to visit a DCA location or attend an in-person meeting. Members must verify vaccination or follow face covering and testing protocols in accordance with that location's requirements. DCA's testing program is expected to begin rolling out next week, so you'll receive details and instructions soon. We know things are moving quickly and there is a lot of information, both official and unofficial. Statewide guidance for the use of face coverings from the California Department of Public Health remains in place unless a local order is issued tailored for the situation in that community. Many counties have revised orders requiring face masks to be worn by both vaccinated and unvaccinated individuals while indoors. I encourage all members and the public to visit DCA's COVID-19 webpage for updates and resources on public health guidance, vaccine distribution, testing plans, and more. As a reminder, 2021 is a mandatory sexual harassment prevention training year. That means all employees and board members are required to complete the training this year. Please be advised that you will now access this training through the Learning Management System, or LMS, which is DCA's training portal. We've created profiles for each board member, and the executive officer should be able to help you log in and access the training. Board and Bureau Relations is also happy to assist you with any questions or concerns you have about LMS. As a reminder, newly appointed and reappointed board members are required to attend board member orientation training within a year of appointment or reappointment. The final training of 2021 will be held on WebEx on October 13th. Please take this opportunity. To attend, visit DCA Board Member Resource Center on DCA's homepage and register through the LMS. As always, I'm here to help. If there's anything we can do to assist, please reach out. This concludes my presentation, and I'll hand it back to Board President Fang.
Thank you, Holmes. I have follow-up questions. If the board choose to meet in person, be permitted between now and the January 22nd.
I'm sorry, I had a hard time hearing the question. Could you repeat it?
Yeah, I think we have some voice issues. So if the board choose to meet in person between now and January 22, this legislation is pending, is that permitted?
Yes. Right now, boards and committees do have the ability to meet in person, and there just needs to be preparation to adhere to all of the public health guidance. So if it's in a county that requires face coverings, everyone needs to wear face coverings, and all members would need to either submit verification of vaccination or go through the testing protocols once they're rolled out.
Thank you. It almost answered my second question, but I just want the other board members to hear that if we choose to meet at DCA, our board's office, should all board members fully comply with DCA's requirement in terms of COVID-19 protocols?
Yes. So if it's at DCA headquarters or if it's in another location, such as a conference center, because the board members will be acting on official board business and interacting with staff and the public, they would need to follow the testing or vaccination protocols.
Okay. So any questions for Director Holmes while she's here from board members? Not, I like open to public comment. Director Holmes, if you could stay a little bit, see if any public comment directed at you.
Thank you, Mr. Board President. I will open up the Q&A. It's now available, and if any member of the public would like to make a comment, please type. I would like to make the comment using the field in the lower right-hand corner of the screen and submit it to all panelists. We are displaying instructions for your reference. Thank you. All right, this is the moderator. I see no request for public comment at this time. Mr. President, would you like me to go ahead and close the Q&A?
Yes, please.
Okay, it's closed.
Okay. I want to remind the reappointed members and the new members to take these trainings seriously. It is required. Can get additional information if you need from staff. So with that, I want to thank Director Holmes for giving us that update.
Thank you. Have a good meeting.
Thank you. Any other public comments on agendas that are not listed on the items not listed on our agenda? See if a moderator you want to open up, see any comment.
Thank you,
Or we move
Mr.
to
Board.
agenda E.
Sure. So the Q&A panel is now available. If anyone would like to make a comment, please type. I would like to make a comment using the field in the lower right-hand corner of your screen. We are displaying instructions and we'll give you a moment. All right, this is a moderator. I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
Now we are on agenda number E. Is review and approval meeting minutes of last board meeting.
I'd like to make a motion to approve the minutes from June, our June meeting.
I second.
I move the motion. Anyone second?
I second.
Oh, Ebony?
Sound like Ebony, yes. Mhm.
Okay, Ebony. Okay, Ebony seconded the motion. And Mr. Secretary, do you want to run the roll call?
Certainly, certainly. Any discussion? Do we have to ask for public comment?
Good question. Sorry. Thank you for reminding me. Either open for public comment.
Thank you, Mr. President. I will go ahead and open up the Q&A panel. It's now available, and if any member of the public would like to make a comment, please type. I would like to make a comment and submit it to all panelists. We are displaying instructions. All right, this is the moderator. I see no request for public comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
All right, we'll take a roll on the motion that was seconded to approve the June 11, 2021 board meeting minutes. Tian Fang,
Yes.
Nilza Serrano. Nilza,
Yes.
you moved, so I know, but certainly. Brett Gladstone,
Yes.
Ronald Jones,
Yes.
Mitra Kanani.
I'm abstaining because I was not present in that meeting.
Thank you, thank you. Sylvia Kwan,
Yes.
Ebony Lewis,
Aye.
Sunny Ward,
Yes.
and Robert Pearman, aye. Motion carries, one abstention, Mr. Chair.
Thank you. Agenda item G is executive officer's report on the board's administrative matters and management examinations, licensing, and enforcement programs. Right, you want take on this? I should introduce Tracy Montez first. What is the arrangement, or you decide?
Yes, let's please have Tracy start for this item, and she, I believe, has been promoted to a panelist.
Are we doing item F or skipping it?
We're doing
Oh,
G.
we did skip item F. Thank you. Do you want to go back to that, Tiana, or take up G first?
Oh, my apology. Do you mind we reverse the order? Oh no, yes.
We can take up either one now, whatever you prefer.
Okay, so we'll go back to, sorry, we go back to agenda item F,
Okay.
Education Committee's report. I will ask Staff Jan Kreindeller and that item. And Ebony was there as well. You can also chime in.
Thank you. Can you hear me?
Yeah.
I hope so. Okay. At the June board meeting, President Fang asked that the Communications Committee meet before the next board meeting to develop outreach program objectives and strategic plan items. The committee met by teleconference on September 1st. The committee formed a subcommittee which will contact schools with architectural programs, one community college, and one California State University each year to educate them about CAB and inquire about questions or concerns about licensure. Another suggestion was to email directors of schools twice a year to solicit information. We also discussed the strategic plan, and the ideas were as follows: to enhance social media to stakeholders regarding licensure, payment methods, resources available for consumers, work with DCA on an earned media campaign to educate the public about resources and the role of architects, use ethnic media to share stories, and refresh and renew communication with firms, licensees, and the public on the core mission of the California Architects Board of protecting the health, welfare, and life safety of the public through regulation of the practice. Also, staffing and current efforts were discussed. One analyst is dedicated to communications, and the current outreach efforts are social media, the newsletter and industry bulletins. The annual practice brief was published last spring. Publications have been and continue to be updated. Videos will be produced. The website will be overhauled, and new publications will be developed. The committee chair also requested that staff send email updates to committee members on outreach efforts, and that reporting will begin the end of September. And that concludes my report.
Anything to add to?
No, I think that covers it. I know Denise and I spoke about just trying to make sure that our meetings are really effective, and having, I mean, there's a lot of requests, and we're not sure if it's like bandwidth on the staff to like make more headway on our communications pieces. So I know she's going to reach out to you, Tian, to like get more of like the history of the communications committee and how we can like move things along a little quicker. But other than that, that pretty much covers it.
Thank you, Jen and Avni. I think very good summary. We'll work on this. We'll all bring some of the topics into the strategic discussion next month. Thank you again. At this time, we need open to public comment.
Thank you, Mr. Board
What is
President.
that?
The Q&A panel is now available. If any member of the public would like to comment on this agenda item, please type. I would like to make a comment using the field in the lower right-hand corner of your screen and submit it to all panelists. If you are not seeing the panel, you can click on the question mark within a box at the lower bottom right. We are displaying instructions for your reference, and we'll give you a moment. All right, this is the moderator. I see no requests for comment at this time. Shall I close the Q&A panel?
Please.
Okay, it's closed.
Now we are on agenda G, Executive Office's report on administration, examination, licensing, enforcement programs, and Laura will arrange this segment. Laura.
Okay, thank you. We can start with the first item. I'm just going to introduce and mention why we have this on the agenda. At the prior board meeting, we had a presentation from DCA's Office of Professional Examination Services. They talked about the California Supplemental Exam and the occupational analysis process. And there were some questions about what the board members' role is and what their involvement can be. So I asked Tracy Montez, who's the chief of the Divisions of Program and Policy Review at DCA, who oversees OPES as one of her responsibilities, to talk to the board about that process. So I just turn it over to Tracy. Thank you.
Good morning. Can you hear me?
Yes.
Great. Thank you for the introduction. I greatly appreciate the opportunity to present today. And I do have a PowerPoint that I believe is going to be shared. Does the moderator have that PowerPoint?
Hi, this is the moderator. And yes, co-moderator, if you can please toggle to our second PowerPoint, and then we will progress the slides, Tracy, as you tell us to.
Thank you. Great. Okay, and you can go ahead and move on to the next slide since I had an introduction already. So the next slide covers various presentation topics. As your executive officer mentioned, OPS made a presentation in June on the results of your 2020 Architect Occupational Analysis. You also heard from OPS about the guidelines and standards that guide the work that they do. So during my presentation, because we do have some new members and also some who may not be as familiar with the work done, I'm going to highlight some of those guidelines and standards and reinforce why we do what we do at OPS. And I do want to share that I have about 30 years of test experience. I've also done some work for NCARB in between my time with the department. So often that's why I will assist OPS and do some follow-up on their presentations because I'm very familiar with the work that's done in the unit. So I'm going to briefly give you a definition of licensure just to kind of narrow our focus on what our discussion is. Again, review some guidelines, mandates. I've also added some legal bases. Going to review some key concepts, the examination validation cycle, which you've seen before, and then focus on the description of practice in the California Supplemental exam and open it up for questions. So it's a pretty brief presentation, but I thought it was very important to add some context before just jumping into questions that you may have. So the next slide, please, has the actual definition of licensure. And I'd like to point out on this slide that this is an older definition of licensure, and you can move to the next slide. Although it's an older definition of licensure, it's a very well accepted and widely used definition because it highlights important parts of licensure. That is, licensure is a process by which an agency of government grants permissions to persons to engage in a given profession or occupation by certifying that those licensed have attained the minimal degree of competency necessary to ensure that the public health and safety and welfare will be reasonably protected, well protected. And again, that's the mission of our boards here at DCA, to protect the public. I'll talk a little bit more about this later, but again, licensure exams are very different than the types of exams that we all are used to in terms of some of our educational exams, our driver's tests, our selection or employment tests, and we'll talk about some key components again that distinguish this. But by starting with this definition, I think it provides a good framework because we're focusing again on that minimal degree of competency, or also referred to as entry level. So let's go on to the next slide, please. And this will be a review for many of you, some of these guidelines here. The Federal Uniform Guidelines for Employee Selection Procedures, although it's federal and it applies primarily to employee selection, which is kind of a normative decision, who's the best, the courts have deemed it credible and applied it to licensing or regulatory examinations, which address entry-level standards. And then, of course, the standards for educational and psychological testing is our primary tool or document that guides the work that we do. And I'll talk more about the concepts in that set of guidelines shortly. But Chapter 14 is devoted to workplace and credentialing testing. And then again, another one that you're very familiar with is Business and Professions Code Section 139. This is based on those standards. Back in the early 1990s, the legislature found that these standards were so important that they wanted to mandate DCA boards and bureaus to follow good testing practices. So while California and the Department of Consumer Affairs has BNP Code Section 139, the standards and the guidelines are national, and they apply to all types of exams, but given whether it's licensure or employment, they apply a little differently. Something that may also be new to you are these policies that I've listed here. OPS 1802, the Licensure Examination Validation Policy, again, is tied to Business and Professions Code Section 139. Again, we were mandated, our department, to create this policy to assist the boards in following good occupational analysis work, examination work, scoring, and so forth. We also have created OPS 2001, which is Participation in Examination Development Workshops. And we did this to really clarify who should be participating in what type of workshop, because we know that different vendors and agencies and associations may operate differently, but in California, we hold our boards to the highest standard when utilizing subject matter experts. And for those of you who are not familiar with that term, in the testing world, it means those who are actively practicing and licensed and in good standing. And those are the individuals in each profession. When we're doing our work, say with the architects board, we want architects who are licensed, actively practicing, and in good standing. Those are the three main criteria. And then, of course, we look for things like diversity, area of practice, how long they've been licensed, again, depending upon the type of work we're doing. We do not encourage or support use of board members, committee members, or instructors serving in as expert consultants in any exam development process, because it creates a conflict of interest where you have individuals who make decisions about tests actually seeing test questions. So it's a mechanism to protect board members, committee members, and instructors. We do use instructors in occupational analysis work because we're talking about the scope, and that can be very helpful. But we created this policy to clarify roles because we were receiving a lot of questions from our board. So those are, again, our guidelines and our mandates. The next slide I've also added here for you, and this is a slide that articulates some important legal bases for what we do, again, with regard to testing. There's constitutional requirements, specifically the 14th Amendment. This has to do with equal protection. Specifically, exams cannot be created to discriminate against an individual or groups of individuals. It also addresses due process. That's fairness in procedure. Think transparency of your exam development, administration, and scoring. It's important to be fair and transparent. We also have statutory requirements, for example, the Civil Rights Act, again, dealing with discrimination in employment settings, educational settings. There's been several acts that have expanded that protection. And then also, I like to include these court decisions because they're really critical in terms of the foundation for the work we do in testing. Dent versus the state of West Virginia actually found that there's constitutional support for licensure, again, going back to that 14th Amendment. Griggs versus Duke Power was really the first landmark case dealing with job-related testing. Individuals must show job-relatedness in the test. It can't be arbitrary. And then Chance versus the Board of Examiners established job-related precedent for tests used with public employees as well as private. So my point of kind of going over these guidelines and these mandates and these legal bases is really to kind of reinforce that there's a strong foundation for the work that we do. And it's not just arbitrary to consumer affairs or to California, but there is a body of research and case law and standards that OPS follows when we do this work for your board as well as all of DCA's boards, and that it's our role to really be able to give you robust recommendations and produce results that can be defensible. So moving on to the next slide, I just want to revisit the definition again. So we've talked about the agency of government. That is you as the board. You grant permission for individuals to engage in the profession or practice of architecture by certifying. That's one word I've highlighted. I'm not real a big fan of that there because certification can mean many different things. In this definition, though, it does mean a minimal degree of competency, which we know is entry level. Sometimes individuals kind of flinch at that word minimal degree, but really what it means is that this individual has attained all the prerequisites to sit for the exam. Once they have done that, whether it's education, training, experience, then they sit for that exam. If they pass it, they have met this minimal degree of competence, and the thought is they will not, they are able to perform without inversely or adversely affecting the public. And so this is where it gets really tricky because the goal here is to have a standard of entry-level competence, but not create an artificial barrier to licensure. And so we have to go through this process to make sure that various properties of the test, so to speak, are met. So let's go on to the next slide, which is the key concepts or properties that we help the board achieve when looking at their exam. And again, you're familiar with many of these. Validity. Does your exam intent measure what it's intended to? We're looking at entry-level practice as an architect, not as an engineer, not as a psychologist, but as an architect. Are scores stable? If somebody took the exam this week and came in a month later without any intervening experience or training, would they be expected to receive that same score? Standardization. Is the assessment process consistent? We don't want individuals using various tools or in various conditions or situations because that creates what we call error in the process. So we make sure it's very consistent in how we assess the test. Fairness. The exam should avoid any adverse impacts. And again, this is very important in the work that we do. And sometimes our candidates or students don't realize that the goal of a licensing exam is not to trick candidates or students, but to be very straightforward. The expectation is very clear. This is what you need to know, and we're going to lay that out for you. And if you are competent and can demonstrate that, you will become licensed. And then the last one is practical. Is the exam reasonable and cost effective? It's okay to consider cost. Sometimes boards have concerns about that, but we have to be reasonable. We only have so many mechanisms and time to evaluate candidates. And so we need to be thoughtful in our process. We can't have a week-long exam, although sometimes some of my subject matter experts would like that. We have to, again, look at all the pieces or the hurdles, as I call them, in the process, and we have to make sure each one is valid and defensible. And I know that that's something your board has done in the past, and we've consulted on that. And that, again, really shows being responsive and fair. So working with OPS, we really try to factor in all of these concepts so that you can have a legally defensible exam and that your pass-fail decisions made from performance are reliable and, again, can be defended. And going on to the next slide, and again, I know you've seen this slide before as well. This is our exam validation cycle. Sometimes it's just called the exam development cycle, but I've expanded it here. And this slide really illustrates how exam development is ongoing. Most people, most laypersons think there's one exam. You have a licensure exam for architecture. No, it is a bank of items in which you create forms. And you do this by conducting your occupational analysis, which was done, and it's updating kind of what happens in your scope of practice. You create an exam outline From that outline, you write items, you review them, you construct them, you set the passing score, you collect data, and it's a process, an iterative process that's ongoing. And at each one of these points, and I'm not going to go through them all, but I can certainly answer specific questions that you may have. Each of these points, we're using subject matter experts. We're relying on research about your profession, and we're consulting with board staff if we have particular regulatory kinds of questions. Now, other components that are on this page, this slide that I've added for you to also think about is how the exam is administered, how it's scored, and that's really the performance of the exam. How well is it doing? Candidate materials, scheduling, the security. All of these components here are evaluated according to psychometric standards to ensure that you meet the expectations for Business and Professions Code Section 139, which is based on the standards. And they're all very key and important in your process. And again, I know NCARB does the same thing too. Any robust examination program is going to work with each of these components and make sure that they are robust. And again, that gives you that valid, reliable, fair exam. And going back to how subject matter experts are used, happy to share that policy with you about the various roles. But this is a methodology that's used. And again, you can see that the various opportunities from input from those in your field. We recommend that this is done about every 5 years. If there's significant changes to your profession, you may want an occupational analysis done earlier. But again, this creates your scope of practice update and then your exam outline, which is the next slide. And I'll wrap this up shortly. But the next slide shows the description of practice. So by going through that occupational analysis, we came up with a description of practice. This was shared with you back in June, and this shows that in California, in general, these are the content areas that we've sort of partitioned the profession into. Then going into the next slide, you were also shown this one, and this is the California Supplemental Exam. So your occupational analysis takes a large snapshot of what's done in California. We take that and we whittle it down to something that's reasonable to examine. In this situation, it even got whittled down smaller because we didn't want to overlap with what NCARB tests. We really wanted to focus on supplemental. And why do we do that? Well, first of all, it's impossible to measure everything. And second of all, we don't want to create barriers by double testing. And so the idea here is that your subject matter experts through multiple iterations said these are the key components and this is how the exam is going to be based. Now the actual test items will go into a much deeper level, but they will be linked to this exam plan because this shows the link between the job, remember Griggs versus Duke Power, that job relatedness. You have your practice or your profession, your job, you have this exam outline, and then you have your test, and it's all linked together. So I'm happy to open it up to questions now. This is, again, I know I went through it quickly, but I wanted to show you some basis for what we do, why we do it. It's not something we make up, but we've really enjoyed working with the Architects Board over the many years and doing these products for you. We are always open to feedback and we'll build that into the process, but our role is also to protect you and to make sure that we can defend your exam with you in the event that there are challenges. I'm not aware of your board having any, but there's been some at national level. We've had some of our other boards challenged, and so we want to be here to support you. So again, with that, I'll open it up to questions you may have. And you can go to the next slide. Thank you.
Can we go back to the previous slides?
Mm-hmm.
So I do have some questions, but I want to open the floor to our members first. Any comments and questions for Tracy? By the way, Tracy, thank you so much for the very effective explanation of the process. And also wonderful to know you actually work extensively with NCOP, so that makes you an architecture expert.
It was a while ago, but yes, I enjoyed it.
Robert Pearman, I have a question, Mr. Chair.
Yes, go ahead, Rob. Your voice is low.
All right, I'll try and speak up. There was mention of one of the factors earlier in terms of, I think, reliability, and you mentioned the goals to be consistent. I was just wondering in that factor, while that's a nice goal, how do you measure if that particular goal has been achieved?
Sure. So what we do is we look at overall exam performance in terms of pass rates, and then we also look at item level statistics. We don't have individual information, but we do keep an eye on the performance of the exam and the items. So we will see if there's large fluctuations in pass rates with the introduction of a new exam plan or a new testing module. Sometimes that pass rate will move up and down. But again, we're really trying to ensure entry-level performance. So there's a number of statistics we can look at to help with that.
Okay. And secondly, in terms of demographics of past takers and past failures, what information, if any, is available in that regard? Does Prop 209 prevent, for example, ethnic type analysis of past fails, et cetera, for the California supplemental exam?
So in California, we actually have a code that prevents us from mandating that information be provided. So some boards are looking at voluntarily providing that. We may do that with occupational analysis information, but we have to be really careful with exams because there are concerns. The reason why the code is there is because there's concerns that individuals could be concerned about demographic information used for pass fail. So bottom line is we can't collect that. We don't have that data, but certainly in the future, there may be opportunities to voluntarily request that information and evaluate that. Again, some national associations do collect that on a voluntary basis, but here with your board in California, we don't.
Thank you. Thank you. I'm finished.
Okay. Anyone you want to raise hand or just jump in before
I'll start with a question for the moderator. On the old WebEx, there was a place to raise your hand, and I'm not seeing that option. Has that been removed?
Thank you, Sunny. It's actually next to your name now. So instead at the bottom
Got it.
of the, you got it? Okay.
Yeah, perfect. Thank you. Okay, so I'll try to use that.
I
I do have a question, and it is to do with the redundancy. How is that checked? You know, as far as like because this was my question back in the summer when we looked at these two slides, and your explanation of how you got from the first slide to the second slide was really clear this time. So I really appreciate that. And that makes sense to me. But when I look at the second slide for the California supplemental examination, the content areas, when they're generalized like this in these 5 categories, they still, to me, when I read them, don't say, okay, yeah, these are California specific zones that we're questioning. They're very still seem broad and things that the NCARB test should be picking up. So how, like, what's the filter that the questions go through to make sure that they can't be asked on the NCARB in order to not double test?
Okay, very good question. So there's actually another document, and we should be able to provide that to you, that actually shows the task statements and knowledge statements within each of those content areas. So one of the pieces of the occupational analysis, and I think Roxandra may have gone over this as well, is we again take your practice and we cracked out these statements of what is performed and the knowledge needed to perform those tasks. And so from that information, each content area is, so it'll be contract development, project planning. Under that's going to be a list of tasks and knowledges. And so it's like a blueprint, think of it. That's the tool that's used with our item writers and item reviewers, our subject matter experts. They're going to take that tool and they're going to go, I want to write an item or a question about contract development, project planning. Then they're going to go look for a task and the knowledge to support that. And it's got to be California related. So then they're going to write that and they're going to link it. So every question that is in your bank is linked back. There's a number and various coding mechanisms. So then again, that goes back to another group who review. Is this California specific? Is it attached? Is it relevant? Is it entry level? There's a whole host of criteria that the subject matter experts are trained on. And then our facilitator is going to make them defend it. Again, is it important? Is it entry level? Do you think they're getting tested on NCARB? Do we want to waste a question in the California supplemental? So a big process, again, to ensure that it is truly California related. Now, it's not to say that there may not be some duplicates, because maybe there's something in California that's similar, but it's really, really critical, important. But the idea, again, is to keep it as narrow as possible. Does that answer your question?
Yes, thank you. I mean, it sounds like there's a very thorough process to make sure that we don't have redundancy, that we're not double testing.
Correct.
And that was my question. So thank you very much for that. That was clear.
We see Mitra has her hand on. Mitra, you have your hand up. You're asking a question. She has her hand down now.
Do you hear me now? Yes. Hello? Do you hear me?
Yes, we did.
Okay.
Yes, we did.
Okay. First of all, I have to appreciate being in this presentation. It really opened my eyes to certain facts. You know, I was involved in item writing for the division of what was called design with NCARB, design development, and something else. It's a long name. And also, I taught a supplemental exam before it became computerized, and also took the supplemental exam of California. So what you presented today, first of all, opened my eyes to certain facts, and I really, really appreciate it, which was for a long time question for me. First of all, in NCARB exam, they try to avoid any kind of specific item writing that is not so broad to the level of national. What I mean is, like for instance, in California, we put a lot of emphasis on seismic, which when I was writing in the item writing, it was not so appealable. The items that I was writing that had a lot to do with seismic, expectation of knowledge, they were not so inclined to it. So, and I was always wondering why. So when I took the supplemental exam of California, it was a lot of questions for me was asked of me related to seismic. And now I'm seeing that it's great that I'm seeing that it means to me, bottom line is, to me, what you have the percentages that you are indicating in here makes a lot of sense, because all these discretionary approvals and the schematic design that has to do with pre-design considerations, that seismic has a lot to do for it. For instance, seismic has a lot to do with it. You have given much more weight to it, which to me corroborates that how much your percentages are working. I really appreciate what you've done, but I think there are much deeper expectation from what or potential with what you have done, particular with me as an educator for years. You know, I've always had question, what is the meaning of degree of minimum degree of competency? And this is something that is very shady, unclear, and undefined yet. And of course, I think with a great, you know, this percentages that you're offering reveals a lot that what is it more we are inclining in the state of California versus other states. I'm not sure about how other states in their supplemental exam, if they are addressing them, but like for instance, in the state of Florida, if they're emphasizing on hurricane, another type of lateral load. But in general, I think this is the beginning of a great deal of work that can be done, and I really appreciate what you have started. Can it be shared with us? Can we have this slides? These slides? That was my next question.
Yes, yes, you can have the slides. And thank you for really emphasizing the difference between a national and a state exam, because national exams are for all of the member states that participate. So you can only ask what is applicable for all of those member states. So the bigger the national exam and the more member states, the less specific you can be, which is why it's so important to have a California supplemental exam when it's needed and when it's defensible. And if I may real quick elaborate a little bit on that entry level or that minimal acceptable competency or minimum competency, there's various terms that are used. We actually at OPS have a working document that we use, and we take it to our workshops because it's very, very critical in a passing score workshop. But it actually has, again, your task statements, and we talk about examples of incompetent, competent, and exceeding expectations, because most of us are going to want to hire an architect that exceeds those entry-level expectations. But we have to be realistic in terms of the do no harm, and that's that standard. So we have a tool, and it gets taken to all of our workshops and discussed and added and modified because we come in with our own personal agendas of who we want to work with. So we have these discussions, and again, that's part of the standards, because the standards are very specific. We do not shift passing rates to gatekeep, and we don't, again, set artificial barriers. So we have to work really hard to keep that standard consistent. And that goes to reliability, to an earlier question.
Thank you.
Laura, you have your hand. By the way, you don't need to raise your hand. You can jump in anytime we share. Laura.
Okay, thanks. I'll go now. Sorry, I see Sylvia has her hand raised too, but hopefully my question is quick. I just thought I'd take the opportunity to ask, because this is something that I've seen come up in the survey results from our strategic plan, and it came up in our last discussion. But Tracy, we've had some people ask why we can't go back to an oral exam for the CSE. And I thought maybe if you could just briefly touch on why we don't use those anymore.
Yes, so that actually was a project I did when I was in between my time with the department and doing work with NCARB. So the problem with oral exams is they have so much error associated with them. It's very hard to standardize them. It's very hard to keep them reliable. They are extremely expensive and time-consuming to administer. So we are really have encouraged our boards over the years to move away from oral exams and any practical or performance exams, because we know that we can write very robust, higher order cognitive processing questions. And what we mean by that is it makes you think. It makes you have to know the material and apply it, so that someone like myself, who is good at test taking, I can't figure that out. I can't read a book on architecture and then pass the licensing exam. So again, we have tools in place to train our subject matter experts. And that's one of the reasons why we don't like instructors, because instructors write different kinds of questions than what you would see on a licensing exam. Also, we did studies with the psychology board way back when that showed, we actually had evidence that some individuals who would have passed should have failed, and vice versa. And so before we were mandated to do that for the Board of Behavioral Sciences, they removed their oral exams and went to a very clinical oriented higher order exam process. And then of course architects followed and some of our other boards. So really for you and for candidates, it's a much more valid, reliable, standardized procedure to do this. And even if you think about the pandemic, what would have happened if you had an oral exam? You would have had to shut down. That's what's happened with a few of our exams that do a performance exam. So again, by having this type of exam, I know you use materials, which is great. Someday, you know, and I think NCARB's going in this direction of doing some videos and some much more, you know, fancy testing. We would like to get there. We're, again, just not there yet with our department. Does that help, Laura?
Yes, thank you. It's very helpful.
So I offer a quick perspective. I was the person that has to carry my drawings and in front of the 3-member panel and walk through all these issues in real life of architecture practice. I found that I know it's very hard to administer and keep consistent between the exams. That is a very powerful, very real, something that you cannot just prepare, memorize things. You really have to, you know, have the solid knowledge, interact with the panel, and convincing them that all the things you were doing. So there are strengths in oral exam, but I'm fully supportive for electronic because that's the future. It's like we don't do hand drawing anymore. So Sylvia and after that, Sunny.
Okay. All right. So I'm going to go back a couple of speakers back to the sort of minimum qualifications. It did take me back for a second when you mentioned that. I'm going, what? Minimum? What do you mean minimum? You know, you're an architect. And then I realized you're absolutely right. I'm just going to pull a number out of the air. For 80% of the test takers, this is the beginning, if you will, of their long career ahead of them. And I was one of those early test takers. I think I passed it, you know, pretty young, like 25, 26. And I remember that I didn't know very much, but I got a license, which meant that I knew enough to be able to go into the practice. And then for the next 40 years that I've been practicing, it has been, you know, continuous learning curve. So I finally came to the realization that you were right, even though at the beginning I thought, that's not correct. Now, however, there is a small percentage of test takers who have practiced all their lives and they never took the test for a whole bunch of reasons. I have several in my own office, and they know more than I do. They know more than most people, but they just never took the test. And just so you know, everybody, I'm trying to work on that issue at NCARB. I am a brand new member of the NCARB board, representing California and the region 6. And so I'm going to try to work with them. They totally understand what I'm talking about. I've talked to other large firms like the one that I'm in, and there are a number of practitioners there who are not licensed after 30 years of practice. They know stuff and they know lots of things that are practical, you know, they're a real true architect, but they can't call themselves an architect. So it's a true dilemma. And I'm going to try to work on something with the NCARB's hopeful participation. As I mentioned, they are sympathetic that this is a real life situation that's been bothering me for a really long time because I owned my practice for 37 years And in my firm, I now have 3 to 4 people that I can say are really, really good. They're true, full architects. They're not licensed. What do we do about this? So anyway.
And if I may real quick, that's really tough when it comes to the licensing exam because it's so general. And when you've been practicing for a long time, you develop this depth and you kind of move away from the general. In some professions, I can't speak to this one, but I know in some professions, like with reciprocity, it's really hard for someone who's been in another state practicing successfully for 20 years. They come and take an entry level test in California and they don't pass it. And it's like, how can you explain that when they have no actions against them? So it's just one thing to keep in mind, again, that the licensure is really entry level. And once you start to specialize, or if you have an experienced pathway, we run into this with our registered dental assistants. They have an education and an experience, and we find the experience struggle because they've got this huge depth of knowledge, but it's not very broad. And so, but yeah.
Wow. Well, thank you for that. I had no idea. That is an excellent explanation for why they can't pass it. Thank you for that.
Okay, Sunny.
If I may add something related to this minimum competency, I did some research for when on the NCARB Education Committee Board. I did some research when we were working on the IPAL program, and I came across one of the research that I did was on the UK licensure and the process that they're taking that pretty much is compatible with what we have started as an IPAL in this country. But what is it's interesting about them that they have a series of lists of specification for what is the minimum competency at each level, because they have levels to achieve to the level of getting ready for licensure, which includes of course some a high degree of involvement of education and practice. But at each level, they have this list of competency that they have to be checkmarked. Pretty much this is what NCARB tried to copy with their divisions, but still it's not as compatible when it gets to the test taking part. It's pretty much addressed in the practice side of it with the internship, which we're not allowed to call it internship. It's called AXP. But when it gets to the exam, it weaves together and becomes unclear. So the realms, the level, the divisions as to what is the level of competency, for instance, in the practice area is not so much well defined. So in here, it was interesting to me, like you're saying, project bidding and construction. But of course, under this, there can be a whole list of minimum requirements, what can be considered in this under this list. So that's why I'm saying that this is a great start for and with a great potential for hopefully much deeper analysis that we can help to my point of view, something that has been my question for all these years, minimum degree of competency.
Sunny, you want something?
Yeah, I just have two comments. One, to go back to Laura's question, and I agree with all of Tracy's response to that. And I think she was alluding in some of the sort of subtext to what she was saying, but I wanted to just say it again because I think the most important reason why we shouldn't have oral examinations is because of the possibility of bias. Just because the diversity level of the architecture field is not diverse, and we have a problem with that. And it requires a large amount of licensed professionals. So therefore, we would not have a diverse amount of professionals that would be sitting on these oral examinations, and therefore the ability and probability for a huge amount of bias to take place, because they are very subjective in how those oral examinations are scored. It really eliminates that bias possibility, which I think is, for me, that's the most important reason not to do them. So I just wanted to say that. I don't know if Tracy agrees with that or not, but I wanted to throw that out there. The second thing is, I'd like to tie this conversation in, because this is important to me. The conversation about testing and communication, and taking it back to the committee, the communication committee, and our correspondence with the schools, because I think there's a real disconnect between our architectural education and licensure. I think it's really great, the IPAL program, and the fact, but really, when we get, the truth is that when you get down to the truth of the matter, the IPAL program exists and schools have it, but they don't supplement it, and they don't really teach practice per se. And I think it's one of the biggest problems that we have. And so I don't know when the appropriate time to sort of talk about this is, but if the board sort of sees this as an important value, that part of our communication and outreach to the schools is to kind of, I mean, look, we don't have the ability to sort of require this, but if we could ask the schools, like, what are you guys doing to teach your students? Like, if you have the IPAL program, are you making sure that NCARB testing and California Supplemental Education testing is part of your professional practice course in your school? Do you have that? I know that your accreditation committee doesn't care about that, but we do. And can you add that to your curriculum? Can you make sure that your professional practice classes in your 5-year and 4-year and master's programs schools are assisting our architects to be? And I think that would be a huge step forward in the practice in this state and across the country, but it would just be so helpful.
Sunny, this is definitely a conversation of a strategic plan. I urge you, very eloquently said, and then make a note to yourself, bring back to the strategic session, maybe either put under the communication committee's outreach to schools. That is the content of outreach I've been calling for a while. What is the objective? What do we want to achieve? This is one of the things you mentioned. It's very, very to the point. So with that said, I do have 2 questions to both Tracy and also our CAB staff. We went through this last time. We want to know that what is board's role, if any, in terms of shaping or the scope, content of the exam at policy level. For example, this 5 items to me is more a project process-based document testing. It is project start with the development, into the design development, and then become bidding and construction. We know, however, though, under this umbrella, what we are testing, what are the subjects we are testing our test licensees or candidates? That is the part with our questions. For example, the concern about climate resiliency. And if I ask, are we testing our candidates about wildfire's impact to the building and sea level rise impact to the harbor, where we know these are incorporated? So that is, I think, was the conversation started with 2 meetings ago. So anyone can shed a light on that, either Tracy or staff.
So I would go back to the examination plan that's in the validation report, and we can highlight that for you and make sure that Laura can share that with you. It is a public document, and it's also good for the schools to see. But that will detail out what is measured in each of these content areas. And then again, our subject matter experts that come in and write the questions are going to write based upon what is going on in the current environment. And so that's where you get into the specifics of the items, which of course we don't talk about for security purposes. We can talk in general in a closed session, but we really prefer not to go into the actual items, what they are. But I think that by looking at the full exam plan, the blueprint, that should give you some comfort in what is actually being assessed. And then again, knowing that we bring in a diverse group of subject matter experts who are working in the field currently from across the state who are actually writing these test questions. And so again, that's what makes it a defensible product, is it's not us writing the test questions. It's not people who are retired and may not know what's happening, but it's people who really understand the concepts that need to be tested.
So the next question is more for our attorney, Mike, and also our two board attorneys, maybe share your perspective. I like to see, would you present the segregation or separation of board's mission with actual content of the test? I see that. However, if board this has a policy, for example, AB 1010, which is sponsored by AIA, wants now all the licensees as part of requirement to renew their license, 5 hours of net zero carbon design. For example, it's very subject specific. And how do we make sure that our California supplement exam actually prepares our candidates in this specific subject area? They could exist throughout the whole entire 5 phase, from contract development, ask the client, you want me to cover that, to the finish the construction, make sure the window is, tornado proof, whatever it is. So should the board member has this, or should we say, well, we want the exam to include some of these key aspects, direct the impacts to the consumer protection?
So it's not so much the board, but it would be, because that would override the occupational analysis process. Rather, what it would be is reminding board staff, and OPS would do this too, is all important legislation that's passed, we need to make sure that that is included in the exam under the appropriate content areas. So again, this protects the board, but it's communication, because that is very important. And that's something, again, that OPS monitors as legislation is passed. We have to build that into the exam. That's why, remember the circle with the ongoing writing and review, because there's times where we have to pull items or questions out of the bank because a new law has been passed and it contradicts something. And again, what we notice is whenever you have new legislation that's passed and those questions are in the exam, they're usually pretty challenging, very difficult. But as that legislation is out there, it's practiced, candidates, students learn it, we'll start to see those items become less difficult over time. And it's really interesting to see how they operate. So again, we prefer that you don't direct the staff or the board or the OPS, because again, we want the process, the occupational analysis process to guide the exam, but you can remind us, hey, this is passed, it's really important, please convey that to OPS. Does that help?
Our member Ron has a hands up. After Ron, if we close this item, I want to talk with the board member about the logistics, housekeeping items of this meeting, about breaks and lunch, that. So Ron, go ahead.
Yes, thank you, Tian. Again, Tracy, I think this is a great presentation, and I really appreciate the level of discourse that it stimulated, quite honestly. As a member of the Regulation and Enforcement Committee, the thing that strikes me about the examination is that if you look at those areas where most of the cases come before the comes before this body, most of it has to do with professional practices. And so I guess my question is there any correlation between or direct relationship between your observations of those areas where practitioners fail to perform and the examination? And so, because it strikes me, and I've said this in previous meetings, that oftentimes those areas of violations happen around the residential practice of architecture. But there should be still minimum levels of competency even in those areas. But as I said before, it has less to do with the technical aspects of construction documents and processes as much as it does with professional practice. I'd just be curious to get your feedback on that.
As far as I know, we haven't done any correlational analysis between enforcement actions and the exam, but that's something we can certainly look into. The programs that we have looked at, it's usually like an ethical violation that occurs. But certainly the way, again, these are developed is based upon importance and frequency. And so what are current practitioners doing primarily in their job, and how important is that for entry level? And that is the data that is used to create this plan. It's not enforcement, because our respondents, our licensees, they may or may not know what's happening in enforcement. So they're basically saying, this is what we're doing now. This is this snapshot in time, most critical for entry level to know. But again, we're happy to see if we can do some kind of correlational analysis, work with your board staff and see if we can draw some parallels to anything.
And I think for me, I think the bigger question is the assumption is that it's ethical decisions made by practitioners as opposed to a lack of knowledge and a lack of understanding of what's required of them. And that's it's the sort of the tether that I'm really trying to better understand. Thank you.
Right. Mm-hmm.
A great conversation. Thank you so much, Tracy. We probably want to have ongoing discussion with you, not necessarily in this full meeting session, maybe email exchanges, so forth. So maybe have more.
Yes, and again, we're very happy to work with your board. Any ideas you have, please just have Laura and her team email them to us, have conversations. We're happy to come back and present as needed. But yes, it's good to have these ongoing dialogues. It's very thoughtful. I've taken a lot of notes that I'll go back and share with OPS. And again, we'll continue to come up with some information to share as needed. It doesn't have to be a presentation. We can just do a memo to present.
Thank you again. Okay.
Thank you.
Members and Laura, I will have a housekeeping item to check in with you. I'm thinking about taking a very short break at some point, maybe after Laura's 5 minutes, then maybe 10 minutes, then we'll continue on with the program. Today we will finish the open meeting part for 1 o'clock, and we'll take a lunch break, and we'll come back for closed session. And that way, logistically, it's convenient for public members as well. They don't need to come back and log on. So how this idea works. Anyone, you raise your hand if it works with you.
Sounds like a good idea to me.
Okay. Okay. Thank you for your support, Secretary. So Laura, let's finish this item and take 10 minutes break.
Okay. I can be brief. Do you want to ask for public comment now, or should we wait? Can we wait till the end of the item?
I think, can we wait until the end of item?
Okay.
Our lawyer, okay? This is the one item G.
It is fine.
That's fine. Okay, go. All right, go ahead.
Okay, so I'll just go briefly over the quarterly report, which is in your packet. We have some information. The upcoming meetings, communications just met, LATC will meet later in this year and do their strategic plan. And then once the board does its strategic planning meeting, which is scheduled for October 29th at this point in person in Sacramento, we then work on, once the plan is adopted, then scheduling committee meetings to begin work on the new strategic plan. There had been some questions about the board's fund condition and loan repayment, and I asked our budget analyst to provide an updated fund condition. I haven't received it yet, so I'll provide that as a follow-up to board members probably by next week, and we'll include more detailed information on the budget. Let's see, going on to the next page, we still have the majority of staff teleworking the majority of the time, and as Carrie Holmes mentioned, the department will begin testing staff that aren't vaccinated later this month, and the department is coordinating that for us. And then information on our new hires and our social media posts. And then going on after that, we have our regulatory proposals. I do want to mention that I think there have been questions in the past, and we've had discussion about how the time that it takes for our regulations to get completed. And so I just want to thank Karen Halbo, who's our regulations counsel. She's worked a lot with our staff and puts a lot of effort into our regulations, and I appreciate that. And we've definitely seen some movement. The ones that are the highest priority right now are the retired license fee regulations, so we can again start issuing retired licenses at that lower fee level. And then also regulations to further define the existing continuing education requirement on disability access, as that we have a deadline in statute for those regulations. So there's information there on page 3. And then also LATC is quite prolific in their regulations and very speedy. And so there's information on their regulations, which for the most part we correspond, but we do have a few where we have areas that we differ. And then going on to page 8, we have our examination statistics. So you can see our CSE data as well as the ARE data. And not in here, but NCARB recently released their latest NCARB by the numbers and a lot of demographic data on their exam results, which I think we can have maybe a greater discussion at the strategic planning session, but it has a lot of useful information for California. And then going on, we have the LATC data, both for, they have a CSE as well as their national exam. And then on page 10, our enforcement statistics. I do just want to mention here, as I said, I've looked at some of the survey results from the strategic plan that I'll share with the board soon, but there were some comments about the fact that not all items make it to the board in closed session. And so I just kind of wanted to distinguish here, when you see the number of complaints received, the majority of these do not make it to the board because they're dealt with, I will say administratively, but they're not considered formal discipline, and that they don't, the board issues a citation, can issue a citation, and as the executive officer, I issue the citation. If the licensee or non-licensee pays the citation, it doesn't go to the board. It really is only going to go to the board if there's a formal appeal of that citation, or in a case where we're going to seek to suspend or revoke a license. So that's a minority of the types of enforcement actions that we deal with. But so in the statistics here, it reflects all the complaints we've received as well as the most common complaints. So that is it for me. Are there any questions?
Any questions for Laura's? What?
I had one. Robert Pearman.
Go ahead.
Yeah. So am I to read that the California supplemental performance was kind of low in the last period? Though again, it's a small snapshot. I mean, that seems lower than the way I recall being in what, 33%.
So you're looking at page 8, the
Table A.
pass rate for the CSE in table A. The pass rate was 67.
Oh, okay. I thought it was less than that. Okay, 60. I misread it. Okay. I take it back. That's okay.
Yeah, the number of exams administered may have been down too. Well, probably not during that time period. So, okay. And I think, Brett, did you have a question or no?
Yes. Can you hear me?
Yep.
Thank you. Just looking at the minutes of the last commission hearing we had, reminded me that I had asked you to report back to us about the follow-up about the state borrowing money from our accounts.
Right. Mm-hmm.
And I had asked what now that the state seemed to have been, seemed to have a budget excess, that what was the plan for them to be paying us back from that borrowed money? Thank you.
Sure. Right. And so the state did recently adopt a budget for the current fiscal year. I did ask our budget analyst to provide me an updated fund condition and give me the information about loan repayment. So I just haven't received it by this meeting. So I'm going to send it out. I should have it by next week. And so I'll provide that as a follow-up to board members in terms of if the repayment is complete, and if not, what the schedule is for that. The loan does get repaid with interest, and it generally is repaid when the board or the special fund needs the money back. But given the surplus the state had, some of those funds may have already been repaid.
Thank you, Laura. Can you provide that to us in some way before the next hearing, or would that be inappropriate?
Yeah, I think it should be by next week. I heard from her yesterday that she was working on it.
Thank you very much.
Good. So we are going to take exactly 10 minutes break. We come back 11:45. Oh no, public comments. Let's open to public comments. Moderator.
Thank you, Mr. Board President. I have opened up the Q&A panel, and if any member of the public would like to comment on this agenda item, please type. I would like to make a comment using the field in the lower right-hand corner of your screen and submit it to all panelists. If you're not seeing the Q&A panel, click on the question marks within a box at the bottom lower right of your screen. We are displaying instructions, and we'll give you a moment. All right, this is the moderator. I see no requests for comment at this time. Mr. Board President, would you like me to close the Q&A panel?
Please.
Okay, it's closed.
All right, we cut 2 minutes from your time. We still come back 11:45.
Mr. President, this is your legal counsel. Just wanted to give a friendly reminder that after breaks, we will need to take roll again.
Oh, okay.
Excuse me, to establish quorum. Excuse me.
Thank you for reminding. Can I ask if Mr. Secretary is back?
I'm back.
Thank you. The council said we need for the roll.
Yeah, I never knew that before.
Yeah. Small stringent lawyer.
Let's see. What do you think? Should I start now?
Yeah, let's start. Well, we give already 46.
Right.
Go ahead.
All right, we have to retake the roll, everyone. So we'll start again. Tian Fang.
Here.
Nilza Serrano. Go back to her. Brett Gladstone.
Here.
Ronald Jones. Mitra Kanani.
Here.
Sylvia Kwan.
Here.
Ebony Lewis.
Here.
Sonny Ward.
Here.
Robert Pearman here. One more time. Nilza Serrano. Ronald Jones. All right, we have a quorum to continue. Those two are missing to start.
Okay. We are on agenda item H. Discuss and possible action on modified proposed regulatory text for California Code Regulations, Title 16, Division 2, Article 5, Section 135. It's about architecture advertising. We're asking staff Idris and Ahmed to present this item.
Yes, hi, my name is Idris Ahmed. I'm an enforcement analyst with the board in the enforcement unit. So we have been working on a regulation for architectural advertising, which would require architects to post their name and license number on advertising. And part of the regulation states that for firms with 2 or more architects, the requirement can be fulfilled by having one person include their license number who is in management control. So the board had approved this regulation in December of 2020. And after that, we began working with DCA Legal to make it a regulation, and we received feedback or for changes that the board would need to approve. So the change that was made is it added the definition of management control to the regulation, which is defined in CCR 134. So we are asking the board to approve the updated regulation. Any questions?
This is Robert Pearman. This came through rec before, but not this most recent change. But I mean, management control was in the regulation we had prepared. They just came up with a definition to specifically cross-reference it, so I don't see any problem.
Any other comment? No, can I ask someone to move the motion? Motion is printed on this packet.
I'll move.
That was Sylvia. I'll second. Robert Pearman.
Okay, Sylvia moved and Robert Pearman second.
Tian, this is Laura. Do you want me to read out the full motion for the record?
Yeah, I would appreciate that. Let's read the full motion.
All right. The motion is to adopt the proposed modified text for section 135, direct the executive officer to take all steps necessary of the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day public comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes as modified.
That sounds fine.
Just rolls off the tongue. Okay.
We can resume the roll call. Thank you, Robert.
Public comment first. You have to do public comments before we take the roll and vote. I thought is what I said.
Okay, I'll counsel what, yes. Mike, should we do public comment first?
Yes, Mr. President, we would need to take public comment, but there may also be some board discussion first as well.
Okay, any discussions?
As a new member, I would like to ask, what is the exact meaning of architectural advertising?
So it's any solicitation or it could be online website, any presentments to the public.
Does it have any relationship with misrepresentation, those that are non-architects and they are advertising for themselves?
Yes, so the intention of the regulation is to increase consumer awareness of who is a licensed architect. And so once they can see that the person has a license number, they can search it on our website to confirm it. So it is related to unlicensed individuals because by distinguishing it from licensed architects, there would be more awareness with the public.
All right, do you want to edit?
And Ms. Kanani, Robert Pearman, I can say part of the genesis of this was website advertising of people who weren't licensed, and staff found they really could not get the website hosts, the Yelps of the world, to refuse to take those ads or police it, so that this was one way we came up with to try and get around that this way a consumer would see a website ad, and if it didn't have a license number, they kind of would be suspicious of the person purporting to be an architect.
Great, thank you. I appreciate it.
Sunny, you have a question?
I apologize. I didn't bring this up at the last meeting when we talked about this, but when I read through the language this week and now again, I don't know, do we feel like internet website is sufficient that to cover social media, Instagram, Facebook, that kind of thing, or does that need to be further elaborated, or does I mean, internet website sounds very 1997. So just worried about that. I'm sure you could sort of define that internally, you know, as necessary, but it's just a comment to that effect.
I thought social media kind of covered everything.
Well, internet website, is anyone in the younger generation want to define that? Does that include, can someone tell me whether that includes social media? I don't know.
Social media is not written in the language, so that's why I brought it up.
Oh.
Could we ask Karen Halbo as our reg counsel, and she's on the line? I don't recall if this item came up during discussion. Idris or Karen can maybe address that, but do we know if it's broad enough to include what the members are talking about?
I don't think. I have not researched whether that covers it, but on some level, the issue is making clear that architects provide a number and prosecuting people who are claiming to be architects who don't have a number to provide. If you really want to broaden this to be sure you include social media, it can be amended, but then that term itself isn't defined in, we would have to be more clear of what that is. Yeah, I don't know if Facebook or Instagram.
I have one more question. Does anyone, like, I realize the intent of this, and I think it's very important, but is anyone concerned that, like, look, I understand what our current staff is and the motives of this are, but future staff, future directors, like the intent of this, right, is to make sure that unlicensed people are not advertising themselves as architects. But how can we ensure that this isn't going to be like, you know, oh, let's get, like, someone's going to go out and say, you know, look at all the architects' websites and all the ones that aren't in conformance, that we're not getting into this, like, you know, parking ticket situation. I just want to make sure that this doesn't become a parking ticket. That would be a drag.
Well, I'd like to point out it's more than just trying to have non-architects not claim to be architects. Many of the DCA boards, there has been a push that the license number is included so that the public sees there's a license number, understands they're licensed with a board, and can go to the board's website and they can look up that licensee.
Totally get that.
So that's a nice part.
I guess, like, part two to my social media question was like, this is like, you know, it's nebulous at best as far as like the extents of where it goes. Like, business card, crystal clear. On the top of your company website, crystal clear. Advertisement in a magazine, crystal clear. Then there's this whole world of, like, you know, press releases, social media, like quick social media things, you know, where, you know, people are just hustling, trying to make a living. And is this going, like, that's the sort of parking ticket comment that I'm making. I just am throwing it out there. Like,
may I say something? This is Brett. Well, you know, I think the language may need tweaking. The internet may need tweaking. Maybe we make it broader to say that you shall not hold yourself out to the public without putting your number on, whatever media, and that's a broad word that could include internet and social media or print media, without having a license number. A separate point that you just made is that this does not say that on their websites they have to put this on there. So I don't think we're going to be able to find someone or ticket someone for not having it on the website. And maybe we can exclude website if you don't want to make this punitive as to all the people out there who currently don't comply. But rather than and so accept out current websites from the statement that thou shalt not hold yourself out.
What I read does say that, Brett, that it does need to be on your website.
Oh, okay. Well, then, we could say it doesn't, and it does need to be on your website. Make that clear, including but not limited to website.
That's clear.
Stuff out to the public. But also, we could say in here that it's perspective, and that there's no intent to discipline or fine existing websites.
Okay, let me.
This Robert Perry, we had discussed that, and basically the idea was it takes a while for this to get through. As we've seen, we've been dealing with this for over 2 years now. One reason why is header rec. I'd hate to tweak it a little bit because then we start this process of floating back and forth again for comments. But the idea was the staff is not going to start off tomorrow finding people. There'll be a sufficient lead in time. It's not urgency legislation that will educate our clientele about this change well in advance. And if need be, we can later put some sort of grace period in it. But I think there'll be a built-in grace period plus education that we intended to ease this in, so that then when it does take effect, people would have plenty of time to go through old business cards and change their website, et cetera, et cetera. I think to Sonny's comments, it is advertising is one of the key terms there, which I think would cover the social media. But the key, I think, is advertising, which is the equivalent to holding yourself out for a business purpose. If you just send an email talking about, I'm an architect and it's terrible what happened in Florida, if you're not trying to get business, who cares? The point is you're trying to get some business. So I think that would cover use of social media to advertise that you want work that should be a licensee required and you don't have one.
I agree with that. Just a follow-up point on this is this is the other problem I have with it. And again, this one has been sticking with me. And again, it's hard for me because I'm trying to advocate for the consumer only, but there's also the architects out there as well, which I happen to be one of. So I'm trying to take my architect's hat off to think about this purely from the public, but it's a little bit difficult. And here's the other reason why, because I believe, and I'm reading through this, and what is the punishment for this?
Well, can I inject something in here from the eye of an educator that has been trying to reach ethics to students for years, design ethics. Nowadays, it's very easy to intrigue people through public media. And many that I know of, that they are very good in image making. They can create websites that they are very, very intriguing. And the public cannot, it's so intriguing sometimes, and can affect the minds of people, public, that they're not aware of all these legal issues. And there are very many that I know of that they're working this way. So considering that image worth 1,000 words, a lot of times one image can make the whole difference. So the issue is how public media is airing or helping or supporting this unethical approach. Number one, to my point of view, is that we need to raise awareness, and I don't know how. Personally, I don't know how it can be done, but it's very important that public become aware of this unethical approach. And secondly, is that of course I personally see that a lot of people need at this juncture need to work, and they are doing it. They're doing it. I know personally many that are doing it.
So I have seen few hands, and because active discussion, I have to go by the hands. Ebony, you're the next.
Hi. Some people use the term architect as just like they design whatever they're designing, and it's not necessarily buildings. And I think that's what, Sunny, I wanted to get clarity if that's specifically what you're talking about for social media platforms, because there's kids and students and people that I see that use that term, and they're not licensed architects working on buildings. Is that something that we are also going to be like doing policing on, or is it just specifically for people that are working in designing buildings and just need to be licensed?
In state law, no one should call themselves architect. The high school students, they may have some other means. I would let Laura expound.
I think Tien, if I could chime in, I think in some ways what Ebony may be referring to is sort of in the software industry, they're software architects. And so the term architecture isn't necessarily limited just to physical structures. I think that's the point I believe that Ebony's making.
If it's a software industry, I had a conversation with my CEO many times. Interpretation is not bad. He said, if anyone, a consumer is looking for design a building, go for software programmer website. That may be something that we cannot help.
Right.
That actually not a bad interpretation. If you're looking for architect design your building, why you go to?
But if I could
software industry looking for
to address Sunny's question about how we would, what we would do with this and what the punishment is. So for that, there isn't a specific punishment assigned to this particular requirement. So in our regulations, we have disciplinary guidelines that define how the board would address these types of violations. But it would be something like the written practice or the written contract requirements we have now. If we get a complaint and we investigate the complaint and find that maybe that they didn't follow all of the written contract requirements, and maybe they didn't include their license number, they didn't include a description of how you would address additional services, but there wasn't consumer harm, we didn't find other problems, we can issue a letter of advisement to the licensee. It doesn't necessarily result in a citation. So staff takes all that into account when we get it in. It isn't that we would issue a citation for every violation at the maximum amount that we could.
That's absolutely the follow-up to my question. So, the concern comes from, okay, the wording is, we can all disagree. It's not crystal clear right now. It doesn't necessarily state all these things. So there's a lot of flexibility for what could be sort of defined as these advertisements. And so that is absolutely I am 100%, I want everybody to know, in favor of this. It's not that at all. It's my only concern is on the back end, it becoming in future administrations like the ability to like people to just go out and like, oh, you know, here's a $50 fee thing that we can go out and get, because it's so easy to find these loudmouths that are out talking on videos and they forgot to leave their license number, you know, at the end of the video clip. And according to this administration, we define that as, you know, not within the guidelines of 135. And so that's my concern. I just want to be sure that like we're not going to run into a situation like that, and that we don't create a headache, that we don't create like a harmful public permanent record for architects that accidentally do something as simple as this, that what we're really doing is going after the people who are unlicensed. And so that's my concern. I just want to be clear that that's the concern.
And if I could opine on that same point, and I guess my question is twofold. One is, I don't think that, let me first make the statement, I don't think that there's an issue with encouraging or requiring that architects properly represent themselves. I think that that's a good thing in the public interest. Having said that, what is the burden, or what is the penalty to the non-licensed individual? What authority do we have to manage that body? And so then secondly, the challenge becomes, as we just spoke about before, as a residential architect, I deal with municipalities and jurisdictions all the time, and you have building officials that refer to draftspeople as architects because they're submitting documents on behalf of the owner. And I'll say for homes, for example, you're not required to be a licensed architect to design a house. So the question becomes, how do you basically really manage, if we're trying to protect the public interest, requiring that a licensed architect advertise themselves appropriately? That's the easy part as far as I'm concerned. It's the non-licensed individual that we're actually trying to better manage, and I'm just not quite sure how this provision allows that to happen effectively.
And it would be similar to, you know, the other requirements we have where we can cite an unlicensed person for practicing architecture, for advertising, for performing services. We can cite them, and then, you know, we don't have the same hold over a non-licensed person that we do over a licensee in terms of payment of the citation, but our collection rate, I think, is maybe a little bit under 50% for non-licensees. I can't recall offhand. I can provide you that. But then also, then we turn over those citations, the fines that are issued, if they're non-paid, we turn them over to a collection agency, which helps to increase the ability to collect from people who otherwise aren't paying. So it is definitely harder to collect from unlicensed individuals, but we follow the same process for them.
Okay, I want to jump into other people. Albany, are you still have your hands up? Are you good? I saw Nilja. You want to say something?
Yes, I do. Thank you. I think the intent of this was to create a sense of safety for consumers who want to engage architects. And I think providing this would be a great service to the consumer. The language does need to be changed, and I think it should include all social media platforms that reside in the World Wide Web. And I don't think we're going to go, the intent is to give protection to the consumers who are hiring architects to provide architectural building services, whether it's designing, building residential homes, or whatever it is that they're engaging an architect for. We're not going to go after someone that is an architect of software or someone that is an architect of fashion, because that also is a thing. So there's architects in many industries, but we are talking specifically for those that provide a service for building. That's all I have to say. Thank you.
I want just to my comments for staff's consideration. I see the benefit of consumer protection. I also see some additional caution that the licensed architect sides, which I'm sympathize with what Sunny said. But in real situation, it may have many scenarios very hard for you to enforce. Staff, I just want you to be aware of. For example, agency like us dealing with large multidisciplinary firms, they do not have that culture. I don't think we can constantly prosecute them, name of it, and now Soviets engage a large firm. When they have the website, you cannot list the license number. They have hundreds of architects, so they don't know who to list to. So you will have some hard time to keep your enforcement consistent. That's just information for you. That does not mean we don't go this way, but I want you aware of many scenarios. It's harder for you to enforce your rule.
Just a point of clarification, this particular language does state that only one architect needs to be listed. I think that's also clear. But I still agree that it's complicated for a large firm.
I don't know if they can even do that for that liability insurance for everything else.
That's right, and across state boundaries and across international boundaries.
Yeah.
Absolutely.
So there will
100%.
be an implementation challenge. I want the staff to be aware. But nothing is perfect, right? We need this, and let's do it. Next body can revise that. So I urge move forward with it. If we really have encountered a challenge, we will revisit this few years later.
Robert Pearman here. I would just say, as kind of head as rec, I'd ask Ron his thoughts and the staff too, but I'm not opposed to adding after internet websites, social media platforms in subpart A, per the concerns Sonny legitimately raised. What do other people think about that? Ron or the staff, what do you think about that?
Just to comment on that, currently, for practical purposes, we do consider social media platforms to be a form of a website, and that's how we would interpret it.
Yeah, again, I think it's a slippery slope. I literally read an article yesterday in the Napa Valley Times where the publication did an article on this person. I won't identify the names or anything like that, but the person purported themselves to be an architect in this article, and I looked the person's name up yesterday, and they were not licensed architects. But the publication published it as if they didn't have a responsibility to confirm that the person who represented themselves to be an architect was in fact an architect. So part of it is that and I think the point is that anything within the public domain, I think, should be properly monitored. But then the question becomes, whose responsibility is it to provide that monitoring? Other practitioners, journalists who basically do these stories. How does that? Who's ultimately responsible for the policing of this medium? And I'm just not sure, or this issue and objective. I'm just not sure how that works.
To follow up on Ron's previous comment, I think his previous comment was the most important thing for everyone to consider this. The fact that the California Architects Board regulates architects. And so this particular requirement is in an effort to educate the public about unlicensed architects, but then there's no way legally to legalize the unlicensed person, but there is a way to regulate the licensed person. And that, I think, is the heart of this, which is a little bit complicated for me. And there's nothing we can really do about it. And again, I 100% think it's a great idea to require architects to list their license number. It's just that we're still not achieving what we're out to achieve in doing that, and everyone just needs to realize that. It's like it's a regulation without tooth, and then to further that, to my point with the slippery slope, it can get complicated fast for some really good people that are licensed architects that had no ill intentions whatsoever. And that's the part that I'm struggling with on this. so if we went to change language, I don't know. I mean, I think I'm in a minority here, but if we went to change language, I'd like to see something that just like, like, I don't know, it's like a weed law, it's like, it's not a permanent record thing. It's not, it's not something that ends on, like if when someone goes to check that person's license number in the future after they've done this, if it's something that they've been, penalized for in the past, does that show up, and how does a future, like, trying to walk this through like the weird possibilities on the other end. So unintended outcomes, I guess, is the best way to put it.
And I'll just say this and then I'll be quiet. One of the things that I struggle with in this whole process, and I've said this a few times, is the whole idea of what's expected of us as practitioners. One of the challenges that I have is that an issue like this is not part of continuing education. If you basically asked architects, are they required to advertise? I mean, I go back, I harken back to the thing that I learned just in my role or my participation on this board, the whole birth requirement for submitting birth forms. I had never heard of that form until I became a member of the board. And so how is that information communicated? And so my feeling is that if it's part of this continuing education process is that there is professional practice education, then architects are forced to learn what's required of them. And I just think the absence of that basically leaves the chance that architects stumble upon the fact that they have to do what level of advertising. And when does it start and when does it stop? So I think finding a way of clearly educating architects through training, through required continuing education, I think is equally as important.
This is Laura. If I could just interject, because we've kind of strayed beyond the agenda item here. But to get to Ron's point that about how we educate licensees about this is certainly something that the board needs to be responsible for, and we can do a better job of providing licensees information on new requirements, and so they can be aware of things like this, like the birth requirement. But just like members of the public, everyone has a requirement to understand that the law changes and they need to be aware of what is required of them. So certainly we can do our part to educate them. Whether it becomes a continuing education topic and that's something the board wants to look at in the future, that's, I think, kind of a separate subject, but certainly we do need to make sure that we educate and promote this requirement if it becomes adopted, because it's a change and we need to make sure people are aware of it. And we would do a lot of outreach and try to publicize it before we would ever look at issuing a citation for it. But to get to Sunny's point about treating this differently from all our other types of violations in terms of how it could be disclosed, I'm not quite sure how we would do that in terms of we have a policy in terms of citations, how long they're available on the website, how long they're publicly accessible, and it applies to any type of citation. So if the board wants to look at treating this differently, I'm not quite sure how we would go about doing that. It doesn't mean it's not possible. I just think that's the bigger question.
I totally understand that and agree. And I guess that just kind of it's definitely like part of what I was talking about, though. It's just like everyone should just be aware that once we pass this, a licensed architect who fails to put their license on a flippant social media hustle video could end up with a citation and a public record that would keep them from getting future business. And this is a licensed architect, not an unlicensed architect.
So, Laura, I don't know if you have the memory, tell the board. If not, we can look into it. So, contractor's license or requires contractor constantly list their license number in any form, even on their truck.
Right.
However, Laura, I see inconsistency. For example, large firm like Turner Construction, so you see their truck, they're not going to put a license number on the Turner, but everyone know they are the construction company. And I don't know how the contractor's license or enforce that rule. So, but coming back though, if we have few members that feel very uncomfortable, I don't think there is such a time urgency. We can even come back and revisit this again. I really don't feel there's a tremendous urgency reaching next 90 days? Enough.
I wouldn't say it's urgent, but we are in the position, the board has approved the language. This was just a modification, so maybe I can defer to Karen to see. I don't really know what we would do now. If the board doesn't want to approve the language today, what do we do with the package? On your question about contractors, they do have the requirement, similar to this, that contractors display their license number on advertisements. They don't, as I recall, they don't issue very many citations for that. It would be more of a letter of advisement if that's the only violation. But the way it's enforced is that it definitely in that industry, it's a lot of reporting on other licensees if they see that the requirement's not being met, which is similar to what happens in both landscape architecture and architecture, is that we'll get complaints from licensees if they feel like a requirement's not being met. But maybe Karen, if you can speak as to what we can do with this package at this point.
If I may add to this, I don't think only receiving a citation will do the job. I think it should be more than that, personally. And one would be to announcement to go to the public. Because for these type of people, spreading the information is more important than just a personal citation to them. And that, I think, does the job more than the citation.
Okay, let's take a informal survey. Should we vote on this today? Anyone feel I should not vote on this?
Can we get Karen's, since she was on mute, can we get Karen's response to Laura first before we do that?
Okay.
Tian, is that okay?
As a rulemaking board, you're not in a rush to do a regulation if you feel it hasn't been considered or isn't timely. I do want you to know many other DCA boards are adopting these requirements so that licensed people have a license number, to the point where the public will start to say, well, if you're that, where's your license number? That's the idea. And so, but it is, you don't have to be, you wouldn't be first, and it's all right if you're last. But that's the move. And the issue of non-licensed people, and some of that, that's harder to control. You might want to not let the perfect get in the way of the good. But I also appreciate the sense that, well, we really want to do this exactly the right way. It's not clear what's the best way, but this has been urged as a policy by the Department of Consumer Affairs that licensees provide their number so that there is a better way for the public to research their standing with that board, and eventually for the public to look for, well, where's their license number? The question of how you're going to educate your people and all that, that's the on-ramp that staff builds, and you have to have confidence they're going to build a good on-ramp to get this but enforcement. But I can assure you it takes a while, at least another 90 days, for the processes to go into place, the public notice comment. It would be interesting to see how the public responds. And the board, once you voted and moved it into a 45-day comment period, you can always choose to stop the process going forward. So
Okay.
You're in the driver's seat. You have the control on this.
Right. I'm thinking actually since we already seconded the motion, and we can open to public comment in event we may even have an interesting topic right here, and we come back to decide to vote or not. Is that okay, Mike?
As far as I'm concerned, that's where we are right now. If there's no more board discussion, you move to public comment, and then you have to take a vote on the motion because you have a motion on the floor.
Right. And before we read it, the motion, before we take the vote and comment, I would like it to be read as it currently stands right now. Can you just, can someone just read it exactly the way it is?
The motion?
Read. You want to
okay, I'll read it again.
Yeah. One more time, please.
The motion is to adopt the proposed modified text for section 135, direct the executive officer to take all steps necessary of the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day public comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes as modified.
Okay. And that's what Sunny has the problem with, is the fact that there's some language in there right now that you don't think is comprehensive enough, Sunny, or what can, you know, 'cause
No,
I'm
to be crystal clear for me, I 100% support this. I think we should do it. The language as it was written, I made a sort of sidebar comment that it seems, as far as defining like the spaces where one could advertise, it's not crystal clear. Based on staff comments, I think, and I'm sure that this language is similar to what other departments in the consumer affairs have listed on I'm assuming, I'm making that assumption, that that's similar. I get it. Like, it's just, it seems a little dated. So that was a sidebar comment. My other concern was simply, just to remind everybody, and I don't, and after hearing myself talk out loud and to other people and other people talk, I don't think there's anything we can do about it. It's just a drag of the current California law that we don't have any tooth as far as unlicensed people are going. So just the irony of this type of regulation is that it regulates good standing architects and not the unlicensed. And so that's the drag about it. And so I just wanted to remind everybody that that's the truth. And in a perfect world, I wish that there was some way that we could separate these, the types of infractions, but based on Laura's comment, I totally understand it. There's not a way to do it. And so be it. If an architect in good standing forgets an Instagram post and gets penalized for this and it gets put on his permanent record, hopefully, God willing, the future clients can see past the silliness of that. And if not, then maybe it's divine order and not in the universe for that person. So anyway, I'll shut up.
Sunny, if I can make one more comment though to your point about your concern that maybe staff would take this too far, it's being on the record. I mean, it is sort of part of the process that I was talking about earlier of the informal discipline process and then the formal. If the board were to issue a citation, if I issue a citation and the licensee or non-licensee doesn't think it's appropriate, they appeal it, they go to a formal hearing, they have that ability, it goes beyond me, it goes to an administrative law judge, and then it can come back to the board. So there is that level of, we think the board staff didn't act appropriately, there is another avenue.
Let's just all hope we don't have to waste taxpayer dollars on those kind of hearings.
Right.
Not inexpensive, but yes, but that process is there.
Okay, let's open up for public comment.
Thank you, Mr. Board President. This is the moderator, and the Q&A panel is available. If any member of the public would like to comment on this agenda item, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. If you are not seeing the Q&A panel, you can click on the question mark within a square at the bottom lower right of your screen. We are displaying instructions and we'll give you a moment. This is a moderator. I see no request for comment at this time. Would you like me to close the Q&A panel?
Yes, please.
Okay.
Do we have any by the way, any public members today? Can we tell? Hard to tell.
We have 10 members of the public logged in right now.
We do. Oh, good. Since we have the motion and the second, I would.
Okay. So we have a motion by Ms. Kwan, seconded by me. Read into the record just now by Ms. Zuniker. Tian Fang.
Aye.
Nilza Serrano.
I'd like to modify the language. I raised my hand, but no one saw it. That it include all social media platforms that reside in the World Wide Web, so that it covers us from any other social media platforms that may come up in the future.
Mr. President, we're in the middle of a vote on a motion. It can't be modified at this time.
Okay,
You
then
need-
my vote is,
Yeah.
my vote is
Can I explain? The staff has indicated, Nilsa, that the website is inclusive. In definition, the website is inclusive of social medias, such as you mentioned.
Yep.
a website is a website, a social ad is a social ad, two different things. So my vote is no.
Brett Gladstone,
Yes.
Ronald Jones,
Yes.
Mitra Kanani,
Yes.
Sylvia Kwan,
Yes.
Ebony Lewis,
Abstain.
Sunny Ward,
Yes.
Robert Pearman, yes. The motion carries.
On discussion, sorry, I don't know why I cannot see your hand, but Nilsa, that apology if there's a hand there.
So I guess
now
the motion
again,
passed, so there's no more comment, right?
Right.
Yeah.
Okay, but I just want to make it clear that it was voted 100% by practicing architects and not the public members.
Mm-hmm.
Interesting. No, Robert voted, and Brett as well, right? Okay, so item, are we okay? Nilsa, can we move on? You have any
Sorry,
other?
yes, I am fine.
Okay, good, thank you. We are now item J, and the possible action of a proposed adoption of a new CCR 16, Division 2, Article 2, Section 109-1, tied licensee application. That item is also well discussed. I have staff Marcus to just to give us the fresh summary.
Tian?
Yeah.
Item I, did we go over that one? Did we?
I skipped
I think we skipped
item
that
U.
one. If we go back to that.
Did I skip it?
There's two more regulation items, I and J. So Marcus, if you want to start with item I.
Yes, I'll go ahead and
Yeah,
start.
start with item I. Yeah.
At last year's June meeting, members voted to adopt CCR section 165 that relates to continuing education. During the regulatory process, our assigned legal counsel for regulations recommended that the proposed text be modified to specify the amount of CE that is required for renewal. The modification would be non-substantive because all it will do is reiterate the requirement as mandated in the statute and is already referenced in the text. But it would relieve the need for architects to research both the regulations and the statute in order to completely understand the requirement. So the specific language, if you see the text, it's under subsection B. It's highlighted and it's 5 hours of continuing education. That is the change that we're asking the board to approve today. And Laura, if you don't mind with that verbiage for the motion.
Sure. Let me read the motion for this item that we're asking for. The motion is to adopt the proposed modified text for section 165, direct the executive officer to take all steps necessary of the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day public comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes as modified.
Thank you.
Marcus, I missed something. Must be last meeting or the meeting before. It is a 5 hour has been all these years. Which part we are clarifying?
The part that says 5 hours, I don't know. In the packet I have, it's highlighted in yellow. It's under subsection B in the 165 text. And we're just adding, the modification is just to state the 5 hours. The text that was previously approved had said, for the purpose of section 5600.05 of the code, a licensee shall complete continuing education coursework. It was recommended by Karen that we be more specific and add 5 hours and say the 5 hours.
Okay, so we add number 5. Okay, thank you. Yes.
Correct. Correct.
Well,
any discussions? I actually like speed up. I'm sorry we cannot rush, but I still want to manage the time part of it. Any quick comment on this? Niels, you have your hand this time?
May I? Can I ask a question? Not knowing the background of this, how has it been that all these years it's been specified as 5? Just this year, I had to take 5 hours of continuing education for accessibility for this reason. So where it came from, if it was not as part of the language?
This is Laura. It's always been 5 hours of CE on disability access. This proposed regulation is defining what qualifies for that requirement a little bit broader. And so in this language, we didn't actually say it was 5 hours in this particular text. So we're just adding it to make it clear that it's 5 hours. So this is a minor change for today. And then this regulation package is just expanding a little bit on the existing requirement for the disability access CE. And I think Niels does have her hand raised to speak after this.
Yes, are we going to use the hand motion, or should I just speak when I need to speak?
No, I want to remind the team we need to use raise the hand.
Thank you. All I wanted to do was make a motion to approve staff's recommendation on this particular agenda item.
I second.
Is that Tian, you seconded?
No, I defer to another person seconded.
Who was that?
I'll second, or I think really,
Sunny.
Sunny.
Sunny, good. Sunny, second.
Yes, I seconded on top of everyone else. Sorry about that.
That's good. That's good. We want that. Let's open for public comment.
Thank you, Mr. Board President. I have opened up the Q&A. If any member of the public would like to comment on this agenda item, please type. I would like to make a comment and submit it to all panelists using the field in the lower right-hand corner of your screen. We are displaying instructions and we'll give you a moment. This is the moderator. I see no request for comment at this time. Shall I close the Q&A?
Please.
Okay, it's closed.
Let's vote, Mr. Secretary. Mr. Secretary, let's vote.
All right. Tian Fang.
Aye.
Nilsa Serrano.
Aye.
Brett Gladstone.
Aye.
Ronald Jones.
Aye.
Mitra Kanani.
Aye.
Sylvia Kwan. Sylvia Kwan. Ebony Lewis.
Sorry. Aye. Sorry about that.
Okay. Ebony.
Aye.
Thank you. Sonny Ward.
Aye.
Robert Pearman, aye. Motion passes.
Thank you. Marcus, please continue on the J.
So the board approved a regulatory proposal to reduce the retired architect license fee at its December 2019 meeting. Regulatory legal counsel, Karen Halbo, determined in the process of working the regulation through that there was a need for a corresponding regulation to codify the application that will be used, and also this new section, section 109.1, would establish and define the application for retired architect license and specify the requirements for a retired architect to restore their license to active status or receive a new license if the original one cannot be restored. So the board is asked to approve this additional text that is a companion to the CCR 144 language, which the board approved back in December 2019.
Marcus, I thought this was also stipulates the exact cost, right?
I'm sorry?
This will also stipulate, if not already, the cost of the certificate. Yes.
Correct. So 144 was already approved and it was working through the process. And it was during the regulatory process that legal counsel said, we need to codify the application as a companion section. And so that's why we're bringing it back. They're together, but specifically we need the board to approve 109.1 that would codify the application and the process for restoring a license if it's capable of being restored, and what they would have to do if it's not capable of being restored.
It's a mechanical fix to cover potential conditions. I like to move the motion.
Niels has her hand up.
Niels, is your new hand?
Yes, I have my hand up. I'd be happy to jump in at any time, so I don't have to put my hand up. Can someone explain to me where it says if the original license can no longer be restored? What does that mean?
So a license, once it has been retired, is only capable of being restored for 5 years from its expiration date. So if I had a license that I wanted to retire today and it expired, say, in November, I would have 5 years from November to either return to practice, and after that point, it could not be restored. So an individual, if they were retired, say, for 6 years and decided they wanted to come back, they would have to apply for and meet the requirements to acquire a new license.
Thank you. That was my only question. Thank you so much.
Sure.
Brett, you have your hand raised. Brett, you have your hand raised. You have a question about this?
Yes, in subsection G, it says that there should be a statement regarding whether the applicant is engaged in any activity for which an architect's license is required. That's fine, but I think it should also say, and should also state what that activity or activities are.
Karen, can you speak to this?
Can we modify the language?
You modify the language, but this is someone saying, I want to be a retired architect. And by having this subdivision G, you have to not be working as an architect to be a retired architect. If you're still winding up projects, you're not retired yet. So the idea is that they will state, I'm done. I'm not doing any more architecture. that's that if they're going to apply to be retired, they need to not be an active practice. I understand you're saying, well, what are you working on? But if you can answer you're still working on, you can't retire in the middle of a project. So it's kind of a question that basically they're stating they're not doing anything. And if they state they're doing something, then staff would not move forward with retiring them. Is that clear?
Brett, I hope that answers your question. And I see Robert Pearman's head.
Two things. One, did anyone second your motion?
No, not yet.
Okay, I'll second it. And secondly, maybe for discussion in the future, the fact that a regulation lays out everything in an application, boy, that sure seems like micromanaging to me. I mean, there should be a little more flexibility in terms of everything we put in applications and things like that. So maybe down the road, Tim, we can discuss whether that's the really way to handle this type of situation.
On Robert's comment on the fact that the regulations listing everything in the application, I think there are two ways to go about this. Generally speaking, Karen knows far better than I do, but you can either reference the regulation by like version number and then you sort of incorporating it by reference, or you can define it all in the regulation. So I think generally we incorporate it by reference. This time we're going a different route. So it's definitely something to consider for future packages.
And I can add to that as well. The way it was suggested to us is this would allow us to make non-substantive changes to the application without having to go through the regulatory process. That's what I understood. Is that correct, Karen?
Yes, and as you're going to electronic applications, the reason it's in regulation is it is a rule that is applied to everybody. And the idea of regulations having public comment is that we don't have secret government rules that are applied to everybody. Before the rule is applied to everyone, there's public comment and you understand how that was created. And an application that they fill out online or on paper is a rule applied to everybody. And so this is actually, it seems longer, but it allows for the electronic format and minor changes in the electronic format much easier than this version. Okay, now we need a new regulation to incorporate this version. It just is actually where it's going with regulations.
Thanks, Karen.
Any other discussions?
Well, I actually don't think that we did get a motion on this, so I can read the suggested motion if board members are willing to make it. It is, the motion is to approve the proposed text for section 109.1, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day public comment period and no hearing is requested, adopt the proposed regulatory changes as modified. Thanks. And I think that Brett has his hand up, so I'm not sure if that's from previously.
No, I do not need to talk. Thank you.
Okay. So
Mr. President, can we confirm who made the motion and who seconded?
I think
I
Sonny
made the
had his hand
motion.
up. Sonny had his hand up to make the motion.
I recalled Tian made it and
Robert seconds.
Robert
Right.
seconded it.
Correct.
Okay. So, moderator, we would like to open to public comment.
Thank you, Mr. Board President. The Q&A panel is now available, and if any member of the public would like to comment on this agenda item, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions for your reference, and we'll give you a moment. All right, this is the moderator. I see no request for public comment. Mr. Board President, would you like me to close the Q&A?
Yes, please.
Okay, it's closed.
And now, agenda number K.
Wait, we gotta take the vote. We have to take the vote.
Try. Could have voted.
Jian Fang,
Aye.
Nilza Serrano,
Aye.
Brett Gladstone,
Aye.
Ronald Jones,
Aye.
Mitra Kanani,
Aye.
Sylvia Kwan,
Aye.
Ebony Lewis,
Aye.
Sunny Ward,
Aye.
Robert Pearman, aye. Motion passes unanimously.
And now on the agenda, K, an update of possible action on legislations, and Laura will cite.
Thank you. Should be rather short. The legislature is will wrap up its business today, so then the governor will have about 30 days to act on legislation. So I have 3 bills here that we've discussed previously, so I'll just give you an update on them. AB 107 requires all boards within the department to issue temporary licenses to spouses of active duty members of the military. We've had questions previously about whether these candidates could be required to take the CSE. I didn't really get any greater clarification from the author's office, so I think that's just something we'll have to continue to look into if the governor signs the bill. There is a fairly high fiscal impact of this bill from the changes required for all the boards within the department, which hopefully will be a factor in the consideration. The next item is AB 1010, which would impose an additional 5 hours of continuing education on zero net carbon design. If the governor signs this bill, the board will need to adopt regulations to further define this requirement. So staff has started preliminary work on that just so we can be ready. And then the last one is SB 607. As it pertains to LATC, it contains implementation language for the fingerprint requirement, and it also requires all boards within the department to waive the application and initial license fee for applicants who are spouses of active duty military members. They currently qualify for expedited licensure, so this is going to give them a fee waiver as well. One thing I did want to mention, I didn't have it on the agenda, but because it's been a topic we've discussed previously, is the issue of naming of architectural corporations. We've had discussions with AIA California about changes at the Secretary of State's office and changes on how they implement the requirement. So there is legislation, language was added towards the end of session into a bill, AB 830, which if the legislature agrees to it today, will go to the governor. So I will update all the board members once the bill signing period is over and let you know the status of everything. So that'll be within a month. Are there any questions?
Questions and discussions? If board member have action on this, it could be just for information. I hear now. I would like open to public comment. Last call, any comments and discussions? Okay, moderator, please open for public comment.
All right, thank you, Mr. Board President. I have opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please type. I would like to make a comment using the field in the lower right-hand corner of the screen and submit it to all panelists. We are displaying instructions and we'll give you a moment. This is a moderator. I see no request for public comment at this time. Shall I close the Q&A panel? Okay, it's closed.
Our legal counsel, if I come back to entertain members' discussion, do I need to reopen public comment?
I'm sorry, Mr. President, would you repeat the question?
If I'm going to entertain more discussion from members, do I need to reopen the public comment period after? Because there's a board member raised the hand and want to talk about it.
I think it depends on whether it's a substantive comment or not. Yeah, yes, if there's a discussion about it.
Okay, Mitra, go ahead.
Yeah,
Just the observation. Go ahead.
it's just a question. What are we? Do we know what is the population that applies to this? Do we have any survey? Since
Do you mean for the number of people who would qualify for the
Yeah.
fee waiver?
Yes.
We don't get very many candidates right now asking for the expedited licensure. It's, I think, in single digits.
Yeah, that was.
Okay, thank you. So there's no action needed, and we can move on to item L, update discussion about NCOG committees and other initiatives. Laura, you want to present this
Let's
item?
start with this one. So this we just have as an item for any members to talk about any of their NCARB committee meetings. I know I'm on the member board executive committee. We met. We don't really have any new issues for this year. Sonny's a member of the credentials committee, and I think he said he had his first meeting. I will mention on the second issue here for the diversity, equity, and inclusion discussion. I think that NCARB is doing a series of, maybe they call them listening sessions, but talking to stakeholders about these issues. And I participated in one with a couple of, they broke it down amongst all the member board executives and had kind of a small group discussion. So I thought that was really helpful. And we did a survey as well. I don't know if any of the other members have had that sent to them. And it's like, maybe Sunny has some, yeah.
I did the same as well.
Mm-hmm. Yeah, me too. That was with the person from McKinley Advisors, I believe. Her name, I'm trying to get is Emily Holthouse. She also interviewed every national board member, and there is a draft, which I just received, a draft report. So I'll be looking at that. Unfortunately, I haven't been able to read it since it just came. But once I get that report, I can contact Laura and figure out a way to share it with the board here. But he is definitely doing that listening session, so I'm pretty sure he'll be visiting California, Laura. I don't know if he set a schedule with you yet. This is Albert Vidori, our president. He hasn't? Okay.
Yeah.
Okay. Do you have more?
I don't have more, so I'll leave it
okay.
for looks like me.
Yeah, I just have one more item, which again was sent to me just last night, so I haven't had a chance to forward to you all. But this memorandum is a new thing that is starting to come around due to the new president just having been, seated. And from now on, I'm going to hopefully get it in time so that what they do is they're going to send us a memo to the regional directors, of which I am one, and it will tell us going forward the meeting that's going to happen in a couple of weeks. It's called the September board meeting, and what they did was they sent each of us a memo so that they would talk about the issues that are upcoming. And I'm supposed to tell you all in advance so that if there are questions about these issues that we can in the future, you can bring questions through me, So they're trying to improve the dialogue, because previously, if I recall correctly, we would find out about what the board did afterwards in arrears. And now they're trying to actually make it in advance of. So today, this time was a little bit late, but one more thing that you should know that we're going to be doing of great interest, I think, to California is that members of the CIDQ leadership are coming to the September board meeting, and we're actually spending 3 hours with them to talk about the possibility of having a national qualifications exam for interior designers through the CIDQ. For those of you who haven't heard of them, it stands for Council for Interior Design Qualifications. They're trying to turn it into sort of a quasi NCARB, if you will. So it'd be like NCARB for architects and CIDQ would be for interior designers. It's a big, big subject. As you know, there's been fights over this for decades. And this is the positions of architects are softening toward this because they're trying to become more and more professional with all these exams, ADA, etc. So I'll give you more information once that happens in September. And that's about it that's really important for the meeting in a couple of weeks. Is there anything you guys want me to bring forward to the NCARB board meeting? Okay, I don't hear anything.
We will do
But
this.
I'm sorry.
That's a loaded question.
Well,
anyone
just so
has,
I'm sorry. Go ahead. Go ahead, Tian.
anyone has specific suggestions or contribution, email to Laura and forward it to. So
Yeah. Just know that the two major subjects for September, one is the whole DEI, or EDI issue, and how they are moving it forward. President Viduri really wanted to express to all of the regions that he's taking this very seriously and he's moving it forward as quickly as he can. Okay, so anything that you want to bring forward to him on that issue, feel free to send it to Laura or me. And then, of course, the second issue that's reared its head is the CIDQ issue. So those are the two major things right now.
So I see two hands raised. And Mitra, you have a question on this old hand.
Old hand, sorry.
Okay, Ron, I saw you put a hand up.
Yes, thank you, Tian. I'm not quite sure if this is the appropriate time, but I do want to speak a little bit about my attendance at the NCARB meeting in Los Angeles.
Sure.
I wanted to say, for me, it was a great experience having an opportunity to talk about some of the national issues, particularly in the area of diversity and equity inclusion. I thought was a great opportunity. I thought that the discourse around that subject was highly discussed at a high level. The amount of passion and interest in that was really satisfying to me, quite honestly. But I also wanted to publicly acknowledge the hospitality that was afforded to us by Nilza during that visit. So she spent time with me, both sharing dinner privately and touring me around Los Angeles. So I want to at least acknowledge that part as well. Thank you.
Nilza is a great hostess.
Yes, thank you, Nilza. And okay, Mike, do we need a public hearing, public comments? This is an information report.
Yes, we do on each agenda item, Mr. President.
Okay. The moderator, please open up for public comment.
Thank you, Mr. Board President. The Q&A panel is now available. If any member of the public would like to comment on this agenda item, please type "I would like to make a comment" in the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions. All right, this is the moderator. I see no request for public comment at this time. Mr. Board President, would you like me to close the Q&A panel?
Please.
Okay, it's closed.
Okay. We have next on agenda is LATC report. Ask staff Trish Rodriguez to enter that item.
Thank you, President Fang. LATC held a meeting on August 4th via WebEx. There are a couple of action items that are included near the beginning of the LATC agenda. I'll pause to allow the board to take action after each of the regulatory proposals, and then continue and provide a brief update highlighting other agenda items. Under agenda item E, LATC was provided an update on the business modernization project by Project Director Lisa Rangel. She provided background explaining that LATC is one of 17 programs currently involved with B2's business modernization project, and one of 5 programs included in cohort 2, which also includes the architect's fair. She updated that cohort 2 is in stage 3 of 4 of the Department of Technology's 4-stage project approval cycle. Upon approval of stage 3, cohort 2 will begin vendor solicitation. The completion of the project is expected in fall of 2023. I should also add that LATC was approved to fill a temporary associate governmental program analyst position to assist with the project. Under agenda item 5, one of the first action items on the agenda is a regulatory proposal to amend California Code of Regulations, Title 16, Section 2620, Education and Training Credits, which was approved by the LATC. The changes are a result of a public comment received during the 45-day public comment period and were made to clarify the original intent of the language and correct the third regulatory text in order to retain an existing pathway for licensure for the UCLA extension program. The proposed language is attached for consideration. LATC is requesting the board to approve the proposed regulatory text for section 2620. Direct staff to submit the text to the Director of the Department of Consumer Affairs and Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process and make any non-substantive changes to the package. Authorize the executive officer to adopt the proposed regulation for section 2620 as noticed during the 15-day public comment period. Thank you. That concludes my update for this agenda.
Any questions for Trish? Discussion? Right.
I should clarify when I referenced I was done with the agenda item, I specifically was referring to the agenda item on the LATC agenda, not the LATC update in full. If the board could please make a motion for approval.
I just want to make sure that members can hear Trish, because the sound quality is a little problem to me.
This is Laura. So just to clarify, this is Trish. This is you're asking for the motion on item M2, the section 2620 education and training credits.
That's correct.
I can read the motion again. This is again modified text, so the language has previously been approved. But the motion is to adopt the proposed modified text for section 2620, direct staff to prepare and submit the final rulemaking documents to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And as no adverse comments were received during the public comment period, authorize the executive officer to make any technical or non-substantive changes that may be required in completing the rulemaking file.
Robert Pearman, I'd make that motion.
I second. Campaign second the motion.
Understood.
Any discussions before we open to public? On, do you have any thoughts on Jones?
Thanks, Tian. No, I actually attended the August meeting. No comments. I think the language was more than
I
appropriate.
don't see a hand raised. So moderator, we will open to public comment.
Thank you, Mr. Board President. I will go ahead and open up the Q&A. And it is now available. So if any member of the public would like to make a comment, please type. I would like to make a comment using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions for your reference. All right.
Just members from LATC in public would like address to the board? Anything you want to add to? If you know.
And this is the moderator. I see no request for public comment. Would you like me to close the Q&A panel?
Please.
Okay, it's closed.
And I have one more item from
Correct.
Trish.
The vote.
Oh, I keep forgetting. The next one also requires a vote. Let's vote on this one first.
All right, call the roll for M2. Chen Feng,
Yes.
Nilsa Serrano,
Yes.
Brett Gladstone,
Aye.
Ronald Jones,
Aye.
Mitra Kanani,
Yes.
Sylvia Kwan,
Aye.
Ebony Lewis,
Aye.
Sunny Ward,
Aye.
Robert Pearman, aye.
Motion passes. Next agenda requires our action as well, and Trish will walk through.
Thank you. This is continuing with my further update. The LATC also considered additional updates to the under L2 of the board agenda to the disciplinary guidelines, which are referenced in regulation. Staff work with regulatory attorney Brian Cabo and to by detailed in cover memo and highlighted in yellow in the guidelines. Due to the extensive changes, I practice I will provide an update and any part of this item.
Okay. Well, we provided a 9-page memo that explained each change that legal recommended to have these disciplinary guidelines be up to date and have the effect and benefits. I'm not going to go over the 9 pages, but I'm sure hoping you looked and went from the yellow highlighted to the description in the memo, and I'm here to answer any questions you have.
Okay, Robert.
We recognizing me, Chen?
Yeah.
Just this question for her or else Laura. In the past, sometimes when we found changes to LATC law or reg, we've realized we need to make companion ones to the ones that cover the architects in general and vice versa. So do these changes parallel things we've already done to architects in general, or do these suggest a precursor to necessary amendments to our other general regulations in this regard?
I think the latter. I think LATC's regs on this area are a little further along than the board. So I've sent this memo and these recommendations to board staff, so we're prepared and we'll work with Karen on the board's package to see what we need to do.
Thank you.
Thank you, Robert. This is also on the radar screen for the strategic session. We like to see alignment between LATC and the board. For that reason, I hope you'll all support me. I will invite members from LATC to participate at our strategic session as well. Okay, with that said, anyone want to move motion? Oh, should we? The quality has some, Trish, your voice kind of quality is not too good. Maybe, Laura, if you don't mind, read the motion.
Sure. I can read the motion again.
Yeah, thank you.
The motion we're requesting is to adopt the proposed modified text to revise the previously approved amendments to 16
I
CR.
had my hand up.
Oh, I'm sorry, Niels, I didn't see it.
We don't have to use the hand thing. I'll just interject myself. Can somebody tell me what on page 24, number 11, respondent shall reimburse the board for blank costs to investigate? Do we have an hourly rate, or how do we determine costs?
Staff here, Niels, well, by the way, Niels, when you raise your hand, it must be a delay. normally when you raise hand, your name will pop up.
Okay,
It's not
so
happening.
it's
So,
page 24, number 11, cost reimbursement. There is no cost or a number associated with actually 2 sentences in that.
In each case, the staff has to calculate what that cost was, and it will change depending on the order and the case involved.
But is there an hourly rate that we should be aware of, or the licensee should be aware of, that it's gonna cost at $250 an hour or $750 an hour, whatever that is, times the amount of hours spent on this case? Do we need to be that defined? Because leaving it blank is just.
Well, because this is going to be used in every disciplinary action, it will be a different number every time. But it's perfectly reasonable to ask, does the staff, for the board's information, have standard rates? I don't know those. But if you put in a number here, this then loses its flexibility and ability to be used as a simple part of putting together the order.
Is there a ceiling like we do, like we have on the architect's board for landscape licensing?
Could you repeat the question?
I'm not sure I quite got your question, Neil. So you were asking if there's a scale for the cost?
Yeah, no, well, I've never seen anything past 7,000 something dollars for fines and.
Okay. So the costs here are different than the fine that we could assess, which generally can go up to $5,000, but the costs are the investigative costs that the staff would incur. So it could be the cost of hiring a subject matter expert to review the case. So I'm just trying to remember offhand. I don't see these a lot for architects, so I don't remember the exact rate, but I want to see subject matter experts.
I just want to clarify that leaving it blank is going to be okay.
Leaving it blank, yeah, is typical, just meaning that it'll be the exact amount for each individual rather than charging them more or less than the appropriate cost. It has to be the exact amount.
Thank you.
Niels, I just want to make sure you can from now on just jump in if I do not see your hand, because there's a delay when you raise your hand. Your name does not pop up. Thank you. Yes, now we are ready for someone make a motion, and Laura has read it clearly.
This is Niels. I'd like to make a motion to adopt staff's recommendation.
Second.
Okay, Yotza made a motion and Ron Jones seconded the motion. Let's go for public comment. Moderate, thank you for open public comment.
Thank you, Mr. Board President. I will open up the Q&A. If any member of the public would like to make a comment on this agenda item, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions. If you do not see the Q&A panel, you can click on the question mark within a square at the bottom lower right of your computer. This is the moderator. I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please, moderate.
Okay, it's closed.
Mr. Secretary, let's vote on this item.
Very good. Tian Feng.
Aye.
Nilsa Serrano.
Aye.
Brett Gladstone.
Aye.
Ronald Jones.
Aye.
Mitra Kanani.
Aye.
Sylvia Kwan.
Aye.
Ebony Lewis.
Aye.
Sunny Ward.
Aye.
Robert Pearman, aye. Motion carries.
Okay. We are now into the last items before the closed session, and I'd like Laura just to walk us through current thoughts if you have anything specific, Laura. What future meetings?
Oh, for future meeting dates. Okay, so our next board meeting would be in person, October 29th in Sacramento for strategic planning. It would be a one-day meeting. As we get a little bit closer to that date, we'll continue to evaluate kind of what the conditions are. Currently, the requirements in Sacramento are to wear masks indoors. So during the meeting, everyone would be wearing a mask and maintaining distancing. So, we'll keep the board members updated, and I'll work with Tian to see how we're going to proceed with that one. But then after that, our meeting would be December 10th, looking at in the Bay Area. And Sylvia had asked me about a location, and I think that staff has a location, but I forgot to confirm before this. So I will send an email to board members with that information. But we'd look at doing that one in person in the Bay Area. And then I skipped over November 5th, LATC is going to meet for their strategic planning session.
So I as the president, I like also have board members' preference expressed. We don't need a survey here. You can let Laura know now, since we have the green light to continue meet remote. So if you have any concerns, you let us know. Maybe we can do a hybrid. I don't know if we can. Do we have a capability to do hybrid, Laura?
We will if the governor signs the legislation that Carrie Holmes talked about. Yes.
Well, but we are entitled to do either between now until January 22nd, according to Carrie Holmes. So they want to know we have a capability to do a hybrid meeting for the members prefer attending remotely. So let's check on that.
I'm sorry, you said you want to check on whether we can do it hybrid for the
That's
next
right.
meeting? Okay, I believe we can, but I'll check and confirm the format.
Okay, great.
And then I think that we skipped over one of the LATC items. If we can go back, Tricia has an update on something that CLARB is working on for uniform standards.
Oh,
Yep.
sorry.
Okay.
Oh, you're missing. Trish, sorry. Come back, please.
That's okay. I know there's a little bit of an audio issue, so I'll just briefly note that OPA has provided a presentation regarding the pathways that we will circle back to discuss further regarding the candidates who are allowed to take the section 1 and 2 early, and we'll continue discussing continuing education. But I wanted to focus on the CLARB agenda item that was discussed during our meeting. CLARB's annual meeting will be held September 21 through 24. The LATC voted to elect individuals for the president-elect and further positions, as well as the leadership advisory council. LATC also discussed the uniform standards recommended by CLARB during recent regional meetings. As part of the uniform standards, which includes a degree accredited by the Landscape Architectural Accreditation Board and 2 years of experience, as well as 8 years experience only after. CLARB is recommending candidates for the accredited landscape architect degree be allowed to sit for all sections of the national exam prior to obtaining your practice experience. The implementation of the uniform standards are on the annual meeting agenda. Staff were directed at the LHC meeting to draft a letter outlining LHC concerns with CLARB's proposal, specifically allowing candidates to take the exam prior to obtaining. That concludes my.
I don't know, other member can hear you well. Anyone has a comment, maybe Laura can help a little bit if you can have an audio.
Yes, I will just add, it was an interesting discussion at the LATC meeting, and I think Ron could speak to this as well, that the direction CLARB is going with the uniform standards really is not really maybe in something LATC would like to see, and they just kind of presented it recently and provided a lot of information, and there wasn't really the chance for feedback yet. So at the CLARB annual meeting, hopefully we can discuss this further. Tricia's attending, and John Roshinsky and I'm going to attend as well. So really interested to see how this is really going to benefit California candidates, because at this point it doesn't necessarily seem like it would. So there's definitely a lot of questions. I think that California needs a lot more information from CLARB before considering this.
Yeah, I would just concur.
Okay, great. I guess we need a public comment again. Just go ahead, do it instead of asking. Moderate, please reopen the public comment period for this item. And
Thank you, Mr. Board President. I've opened up the Q&A panel. If anyone would like to make a public comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions.
Okay. By the way, before I forget,
All right, I do not see any requests for public comment. Would you like me to close the Q&A panel?
yes, please.
Okay, it's closed.
Okay. So there's two things we need to decide. One is how long the break. I suggest that we come back, meet at 2 o'clock if it's okay with you. 2 is ask our legal counsel. We finish all open meeting agendas, and we are going to close session. And I hope we don't need to reopen the public session. Please confirm.
In a very technical sense, after closed session, we will briefly go to open session only for purposes of adjournment. But in accordance with our agenda, we don't have to webcast that or reopen WebEx. So for members of the public, this is the end of the public portion of the meeting.
I hope all public members hear that we do have the welcome back call for adjournment, but we will not have any discussions. So with that said, it's 2 o'clock okay, or 2:15? Any brave first member want to voice your opinion? 2 versus 2:15.
2:15 for me.
Okay, 2:15. That's final.
That's
for
fine.
You and for all. Okay. All right. See you
Okay.
at 2:15.